Do you need CLE credits but don't have the time? Is a busy workload stopping you from earning your continuing education? Well, don't let the daily grind of everyday work life stop you from experiencing cutting-edge CLE programming. Just log on to nacdl.org/on-demand for NACDL's expansive collection of on-demand programming. Just select your favorite program, check out, and get ready to experience compelling and convenient on-demand programming for a wide variety of topics, including DUI, drug cases, cross-examination, sex cases, mental health, and more. If you need last-minute CLE, NACDL On Demand is available 24/7. Whether at home, in the office, or traveling, NACDL On Demand is available for access anytime, anywhere.
Good afternoon. My name is Theodore Simon. I am the president of the National Association of Criminal Defense Lawyers, or NACDL as we call ourselves, and a trustee of the Foundation of Criminal Justice for Criminal Justice, the FCJ. NACDL and the FCJ are proud to bring you this two-part webinar on the state of the grand jury in America. Like much of the nation, I have been transfixed with the furor over recent cases which unarmed black men were killed by law enforcement. Many of our members have views not only on these cases, but on the inevitable varying issues that necessarily arise from these tragic circumstances. All of these issues are important. The fair and equal treatment of all persons regardless of race, religion, gender, ethnicity, sexual orientation, disability, economic station, or other demographic characteristics. The independent criminal investigation of law enforcement officers by prosecutors that do not oversee the same officers on a regular basis, and grand jury reform. For many years, the association has had concerns about the integrity of the grand jury process and the overwhelming influence of prosecutors over that process and its outcomes. Some commentators have compared the grand jury to England's Star Chamber. Whether or not this is hyperbole, it highlights the institution's most notable feature and one of its greatest flaws: absolute secrecy. Secrecy is anathema to liberty and to our adversarial system of justice. As the aphorism goes, justice must not only be done, it must be seen to be done. In today's grand jury, neither is true. And as the reach of the federal criminal justice system continues to expand, so does the inherent danger in a charging system characterized chiefly by secrecy and unchecked government power. Federal grand jury procedures contradict much of what Americans take for granted in their criminal justice system. Only before a grand jury can the government compel someone to appear and face questioning without an attorney. The rules of evidence that govern trials do not apply, opening the door to illegally seized evidence and coerced statements and hearsay. The target of the investigation has no right to testify or present evidence, nor is the prosecutor required to present grand jury with evidence that would exculpate the target. While the defense bar and some academics have long sought to expose these problems, the hallmark secrecy of grand jury proceedings has largely spared the institution significant public scrutiny. That is, until recent events in Ferguson, Missouri, and Staten Island, New York. While much of the public dialogue emanating from the loss of lives in these cases has centrally focused on race and the unfairness suffered by persons of color, within the criminal justice system, there emerged a growing chorus of voices concerned with the way in which grand juries in those cases were handled by prosecutors. Television commentators and members of the print media who denigrated the failure to indict advanced the adage that a good prosecutor could get a grand jury to indict a ham sandwich. The commentators thus argued that if prosecutors can indict without any evidence, they certainly should be able to indict these officers, or else there is a failure in the process. Yet even as the public discourse expanded to point out that the grand jury is but a tool of the prosecutor, there was no discussions concerning the fact that the grand jury system is broken, that it has deviated from its historic duty to protect the public from the sovereign, and that it has moved away from its duty to act as a shield rather than a sword. The grand jury system is broken, not just for the racially charged case or when the potential target is law enforcement, but it is also broken when an everyday run-of-the-mill indictment is involved. In 2000, NACDL assembled a blue ribbon committee comprised of former prosecutors, academics, and practitioners to examine the federal grand jury system. Among the distinguished committee members was today's panelist, Gerald Lefcourt, who will talk more about these recommendations. The proposed reforms modeled on the ABA policy include 1, the right to counsel for grand jury witnesses who are not receiving immunity, 2, an obligation to present evidence which may exonerate the subject or subject of the offense, and 3, the right for targets or subjects to testify. Several states, including New York, Colorado, and Massachusetts, have successfully incorporated many of these proposals into their grand jury systems. Not surprisingly, federal prosecutors have doggedly sought to preserve their unbridled authority. Pushing aside the experience of the states, prosecutors have argued that proposals would compromise the secrecy and efficiency of the grand jury system. One argument you do not hear is that today's grand juries independently and vigorously review the prosecutor's charging decisions. The institution's resistance to incremental reforms, in addition to lessons from Ferguson and Staten Island, raise another question. Should we simply abolish the grand jury in favor of public preliminary hearings? This, of course, most pertinent to states that continue to utilize grand juries, but we may want to ask the same question at the federal level in spite of whatever hurdles are presented due to the Fifth Amendment's language that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. I look forward to today's discussion and the many proposals for not only strengthening our adversarial system, but ensuring equal justice and better policing for all of our citizens and in all of our communities. Now, I'd like to introduce the moderator of our first panel, Roger A. Fairfax, Jr., Professor of Law and Associate Dean for Public Engagement at George Washington's University School of Law. Professor Fairfax teaches courses on criminal law, constitutional and adjudicatory criminal procedure, criminal litigation, and seminars on the grand jury, white-collar criminal investigations, and criminal justice policy. His scholarship has been published in his excellent book, Grand Jury 2.0, Modern Perspectives on the Grand Jury, and in a number of leading journals. Before joining GW's law school, Professor Fairfax served as a federal prosecutor in the Public Integrity Section of the Criminal Division of the United States Department of Justice. Following his government service, he was counsel in the Washington, D.C. office of O'Melveny and Myers, where his practice included white-collar criminal and regulatory defense, as well as pro bono indigent criminal defense and civil rights litigation. He has advised local, state, and national government officials and candidates on criminal justice policy, and recently worked on criminal justice reform as a senior legislative fellow with the United States Senate Judiciary Committee Subcommittee on Crime and Terrorism. Professor Fairfax graduated with honors at Harvard College, the University of London, and Harvard Law School. He is a member of the Edward Bennett Williams Inn of Court, a fellow of the American Bar Foundation, and an elected member of the American Law Institute. With that, I turn it over to Roger. Thank you. Thank everybody.
Thank you, Ted, for that generous introduction, for introducing the panel topic, and for your leadership of NACDL. So I'm very grateful. As a former federal prosecutor and criminal defense attorney and now a grand jury scholar, I'm particularly excited about this topic and the wonderful collection of distinguished panelists we have with us this afternoon. So without further ado, I will introduce these panelists and we'll delve right into the subject matter we have before us. To my immediate right is Carol Elder Bruce, partner at K&L Gates, who's had a distinguished career in both the private and public sectors. Carol served as special counsel to the U.S. Senate Select Committee on Ethics in the investigation of matters concerning Senator John Ensign, and earlier Ms. Bruce served as the independent counsel to investigate matters concerning Interior Secretary Bruce Babbitt. She previously served as the Deputy Independent Counsel in the investigation of matters concerning Attorney General Edwin Meese, and was an AUSA here in D.C. for 10 years, where she handled many jury trials and managed many grand jury investigations and appeals. Carol's a fellow in the American College of Trial Lawyers, serves on the honorary board of the Mid-Atlantic Innocence Project, and is a long-term member of the George Washington University Law School Dean's Board of Advisors, as well as a master in the Edward Bennett Williams Inn of Court. To my far right is Professor Niki Kuckes, Professor of Law and Assistant Dean for Strategic Planning at the Roger Williams University School of Law. So after graduating from Yale Law School, Professor Kuckes won a coveted clerkship with a judge, now Justice Antonin Scalia. She then went on to the legendary D.C. law firm of Miller Cassidy, where she developed a sophisticated litigation practice, and for almost 2 decades focused on white-collar criminal matters, among others. Professor Kuckes used this expertise to develop a strong reputation in the area of grand juries and prosecutorial ethics. And before she joined the faculty at Roger Williams, she was the distinguished practitioner in residence at Cornell Law School. She has been a full professor at Roger Williams since 2009 and writes frequently in the area of grand juries. To my far left is Gerald Lefcourt, a past president of the National Association of Criminal Defense Lawyers and a past president of the New York City Criminal Bar Association. He's also a founder of the New York State Association of Criminal Defense Lawyers and is head of a 4-lawyer firm in New York City, Gerald Lefcourt PC, which specializes in the defense of criminal cases and complex civil litigation. I think he's won every award the New York State Bar has to give, and he serves as a Speaker of the New York State Assembly's designee to the Statewide Commission on Judicial Nominations, which recommends to the governor a slate of candidates for the New York Court of Appeals. He also serves as chair of the Criminal Advocacy Committee of the Association of the Bar of the City of New York and serves on the Magistrate Selection Committee for the Southern District of New York. To my immediate left is Gina Sims, a principal in Oberkaler's Government Investigations and White Collar Defense Group. Before she joined the firm, she served as an AUSA in Maryland for more than 10 years, handling many types of matters, including white-collar matters, many grand jury investigations, and served as the criminal health care fraud coordinator there, where she and her civil counterparts screened cases for parallel prosecution. Following the Deepwater Horizon disaster in the spring of 2010, she was detailed to the Department of the Interior's unit as an investigative counsel in the Investigations and Review Unit, and used her expertise developed at the U.S. Attorney's Office to contribute to that effort. In addition, Gina served as an AUSA in the D.C. U.S. Attorney's Office for several years, handling many felony and grand jury matters there, and previously served as an associate independent counsel under independent counsel Ralph Lancaster as part of a team that investigated a former Secretary of Labor for campaign finance related violations. And as a proud member of the GW faculty, I've mentioned Carol's connection to the law school, and I have to mention that Gina also received her degree from George Washington University School of Law. So with that, I want to get us started. And I think, whenever there's a policy discussion regarding the grand jury, we sometimes neglect the broader constitutional role and historical origins of the grand jury. So I'm going to ask Professor Kuckes to start us off by giving us some context for the contemporary debate regarding the grand jury by situating the institution within that broader constitutional and historical context.
Sure. Thank you very much. First of all, thank you for the introduction, and thank you to NACDL for inviting us here. I'm really happy to be here to talk about this, and it's a very timely discussion. Let me say before I get to the history that what interested me in the grand jury to begin with, I remember as a brand new lawyer being sent down to the courthouse with one of our clients who was going to testify as a witness before the grand jury, and I remember sitting out in the hallway outside the grand jury room, and I can remember the chair, and the client would go in with the prosecutor and 23 citizens and answer questions and come out. I couldn't go into the room. I couldn't find out what was happening. And then they'd come out and we would madly debrief them and try to find out everything that they said and everything that the prosecutor asked and write all that down, and then they'd go back in. Hours, right? So even then, it just struck me as such a bizarre and strange institution that it was actually the first thing I started to study when I turned to become a legal academic. So let me start with that, the Fifth Amendment, because obviously the grand jury was a pre-existing, very ancient institution in England. In England, there was a common law right both to a petty jury, a trial jury of citizens, and then also in criminal cases, a right to be charged by a second group of citizens constituted as a grand jury, and that would also have the power to investigate certain crimes. And it was important enough when the United States was founded that it was actually elevated from a common law right to a constitutional right. It was actually put into the Constitution. But it's also worth focusing on what that language says, because all that it says, right, is no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. And what's interesting there is it doesn't say anything specific about the procedures. What it does say is this is important enough that it's actually a constitutional right for the accused. So the predominant function of the grand jury, as according to the Constitution, is as this shield, right? That the citizen body is acting as a shield between the citizen and the criminal process, which now obviously instituted by government prosecutors. Now, the grand jury, if we sort of go from that point, right, to where we are today, it seems really like a shadow of its former self. It's very hard, actually, today, I think, when you look at the grand jury to understand why it would be a constitutional right for the defendant if we actually look at the process. Because when you look at it, prosecutors are the ones who tend to like the grand jury. Defendants don't necessarily get a very good shake there. And I'll talk a little bit just historically about how we got here, and then we can talk about where we can go from here. So it was very early on, the grand jury right was actually thought to not really be one of those really essential rights. In 1884, the Supreme Court actually held that the states were free to go and design their own systems. It was not one of those rights that was incorporated and applied, that citizens had that right as against the states. So the states were sort of cut free, and they could go off and they could decide, for example, to have criminal charges instituted by a prosecutor, followed by a hearing before a judge to determine that there was probable cause in the evidence proceed with the charges. So the Supreme Court very early on took a fairly progressive view of it, that this is a screening mechanism and there's other ways to do it. But obviously it's still constitutionally embedded in the federal system. And so sort of as the 20th century came along, early on you started to get inklings that maybe the grand jury was not really working as it was originally intended. And it got much worse, I think, after 1950, when the Supreme Court decided a really fundamental decision, the Costello decision. And that was the decision where they said, the grand jury, yes, it's an important right, but you got to understand the process. The grand jury can hear any kind of evidence. There are no evidentiary rules. They can hear hearsay. There's no regulation of the evidence. Doesn't have to be any particular indicia of reliability. And, as important, there's no judicial review of the evidence that the grand jury hears. So that as long as an indictment, once it's actually voted on by the right number of grand jurors and issued and is facially valid, we do not look at the grand jury process. There is no judicial review. And that led to a lot of decisions that really, really watered down the whole grand jury process. So now we really end up with, so I'll just give a few rules, right? When you start looking at them, not only can the grand jury decide to criminally charge somebody based on hearsay, they can use evidence that's unreliable. They can rely on evidence that would be inadmissible at trial, even evidence that's damaging, even if they got the wrong legal instructions or no instructions at all. The indictment is still valid. And the prosecutor who is in the room with the grand jury the whole time is the person who acts not only as the advocate for the government in the grand jury, but also the neutral legal advisor when the grand jury has questions. So it's not really, when you look at, and these are just a few of the many, many, many rules, procedural rules, by which that grand jury right is given reality, I guess you would say. So when you look at that body of rules, it's not surprising that we would have a lot of people saying, look, it's just not working. We need a screening mechanism. This is the one that's built into the Constitution for serious criminal federal offenses, and it's not working as it was supposed to.
Well, so thank you for that, Niki. And I, your reference to the shield conception of the grand jury or screen and the investigative use of the grand jury, I think is a central dichotomy. And I think it segues perfectly to what I want to ask Carol, because our current policy discussion, I think presumes that the grand jury is a necessary feature of the modern criminal justice system and administrative state. But there perhaps are features of the grand jury's powers that might be better found or situated in other investigative or adjudicatory mechanisms. And to what extent is the grand jury really a protection for the defendant as opposed to an investigative tool for the government? So I wanted to throw those questions at you and see what you would like to contribute to the discussion.
Okay, so the first question is whether or not the grand jury investigative powers could better be or might be situated in some other governmental body or entity. And that's what I'll handle first. First of all, thank you for inviting me. Thank you to NADCDL for inviting me, and thank you, Roger, for your personal invitation to me to participate in this panel. Yeah, of course, there are other areas of the federal government or the state government where an investigative body could handle an investigation of alleged crime. But if you were to do that, then you would be, if you would to eliminate the grand jury or skip over the grand jury and choose to go just to a prosecutor or just to a police investigatory body, then you don't have any community input into the decision of whether or not someone should be charged. So we just heard from Niki about the investigative background of the grand jury. A grand jury is supposed to be an investigative body as well as an accusatory body, not not, even though there was and still is a vision of the grand jury in the ideal state to also be protecting and acting as a shield to protect. And I always told witnesses when I was a federal prosecutor or when I was serving in the various capacities you referenced earlier as independent counsel or as a special, well, not as a special counsel, but as an independent counsel, I would tell witnesses that the whole purpose of the grand jury that they were about ready to enter to testify, the main purpose of the grand jury was to act as a shield for, or to stand as I'd say a buffer between the prosecutor and an overzealous prosecutor and the defendant. So that would be my general advice, and of course I'd expand on it depending on who the witness was. But I believe that then, and I believe that now, is that is what one of the main purposes is of the grand jury, but they're also an investigative body. They are supposed to be not just sitting there as a prop for a prosecutor, sitting there as like a theatrical backdrop to the prosecutor's show. They should be actively involved. And so when you even suggest that that function of investigating crime, the investigative powers is what you said in your question, should be transferred somewhere else, that scares me more than what Ted said in his opening remarks about how secrecy is anathema to liberty and justice. It scares me a lot more that we would entrust all of that investigative power, and I know that some of the states are doing it now. Thank you, Niki, for telling me that. And I did know before, but you put a nice point to it. That all of the prosecutors who can flip a coin and say, well, I'll take this to the grand jury, and then I'll take this and do it on my own and return a presentment. I'm sorry, that really that would trouble me. Because the prosecutor, whether it's a state or a federal prosecutor, who is deciding to take something, if you make a constitutional, we have to have a constitutional amendment to eliminate the federal grand jury. But in a state, if they are going forward against an individual without the benefit of a grand jury, then they are not benefiting from the wisdom and the life experience and the common sense of the grand jury. For somebody who did spend many, many years as a prosecutor in a grand jury, I can tell you my style was to bring them into the case quite fully, not just issue subpoenas on their behalf without asking them, which you have the right to do as a prosecutor, and not just go out and prep witnesses and bring in police officers to give triple hearsay testimony. I'd bring real witnesses in to the murder or to the armed robbery or to the burglary or to, in the federal side of the office, to the white-collar crime that I was investigating. And for the most part, good prosecutors, and many of them are found in the public integrity section still, use a grand jury in that way. They don't just put in triple hearsay testimony, which is almost worthless to a grand jury. You may as well be doing the investigation without the benefit of the grand jury. So to have that community involvement is key. The other ways in which you could do it, well, think about the ways in which it is done with state prosecutors. You do have just the police conducting the investigation. And I think whether it's a state prosecutor investigating it on their own or a grand jury investigating it, I disagree with Ted's comment about secrecy as the anathema to liberty and justice, because at that point in the process, when something is under investigation, I want it as a defense attorney to be secret. I don't want my clients, the fact that my client is suspected of a crime, to be on the street. Now, oftentimes the Justice Department breaks its own rules and it issues press releases about investigations. And so in the federal sector, that's a no-no, but it happens, especially in the long-term investigations. But if they're going to be issuing press releases calling my client, not identifying him by name, but saying suspect number A or B in a complaint that's been filed against somebody who has now entered a plea of guilty, did the following, and they're telling the whole story, if that's all they do, even though that's damning and damaging to my client, at least the rest of the investigation is under wraps, and my client can try to maintain his reputation for as long as he can. When I served as a special counsel in the Senate, we used just the subpoena power, just brought people in, had them under oath, and conducted the whole investigation as if there was a grand jury there, but there was no grand jury. So we used that power of the compulsory process to get witnesses in quickly, expedited the investigation, and got the work done. and, though, involve the defense attorney in the case. And that, too, is something that, whether you have a grand jury or not, the defense attorney is going to be involved as much as he or she can be in the actual investigation. So when I wear my hat as defense attorney all the time now, I am in there, and every defense attorney should be in there as much as possible to affect the investigation. How do you think it's going to be different without a grand jury? You're going to be trying to seek to influence the same prosecutors or the same detectives or other investigative agencies. So when I think of, can the investigative powers live elsewhere? Of course they can, and they do. The FBI or any federal or local investigative agency investigates on their own with the power of that grand jury subpoena, but they're out there interviewing witnesses, they're developing evidence, they're developing sources, they're finding physical evidence, they're finding other evidence to indicate the intent of your client, and they're making all the mistakes that they would make were they working in the grand jury, and that's your job as a defense attorney, is to get in there and to try to interdict that, to try to influence them that they're going down the wrong path here, there, or with the grand jury. And so to me, the success of the process, there are going to be investigations. People are going to be investigated for crime. They're going to be accused of crime. You want to have the benefit of a grand jury, and to have the benefit of a grand jury, to me, means to try to persuade the prosecutor, let your client testify, if your client's a target, if that's in your client's interest to testify. Yes, I've sat outside of many a grand jury room and cooled my heels and thought, why can't I be in there? And I'm dying to hear what Jerry has to say about his experience in New York, where you actually can be in the grand jury room in the local system. But in the federal system, that's not going to happen anytime soon, I don't believe. And so, and when I think of the alternative of having no grand jury at all, no opportunity to appeal a client or who's a subject, a witness, or a target to actually speak directly to her community or his community in the grand jury room, in the confines of that room, so it's not on the street where everything's being aired while it's in the investigative stage, then I think that it's, again, a mistake not to use, as a defense attorney, the grand jury as much as possible. To use your access to the grand jury or access to the prosecutors as much as possible. And with witnesses, to be counseling them in the current state, to not go in there for hours at a time. But I know, as Niki knows, is that when you tell them, come out every half hour and ask me questions, I know it's not going to happen. And that's one of the dangers of a grand jury, and I wish it were otherwise here. It certainly is otherwise in other countries and in some states where you can have the counsel present. There's no reason not to have a counsel present in the grand jury. But those are reforms that you'll speak of soon. But that's my general view, is that while there are definitely, it already exists, other avenues where how investigation can be conducted, it's better to have that community involvement, and where they're not sitting as just props. With respect to, is it primarily for the protection of the defendant or as an investigative body? It's primarily now an investigative body. And I don't mourn that fact, that they're primarily investigative body. What I mourn is that the prosecutors who don't use them the way they should be using them, to ask them, well, what did you think of that witness? Did you believe that witness was credible? Do you think who else do you think we should bring in? These are the questions you should be asking the grand jury. Bring them into it. They're just a sort of a preview of what it's going to be like to try this case. How stupid is it of a prosecutor to put in evidence that will be deemed inadmissible at a trial? Why put that in front of a grand jury? The only reason to do that is to taint that body and to try to get that body to vote your way. And that's a fool's errand if that evidence is going to come out. And if you're later going to have your own reputation as a prosecutor damaged because there'll be a transcript. Thank you, Congress, for that amendment, at least. What was it, 1979? introducing transcripts, and the requirement to have a transcript. It seems to me, no, it should be and does in many instances, and maybe you won't, people in the room and on listening to the webinar won't agree with me, but in many instances when you have, and it does depend very much on the prosecutor. If you have an ethical prosecutor, somebody who has integrity, somebody who, yes, wants to build a case because they have evidence they believe warrants building a case, but will have an open mind and doesn't want to hear about it for the first time when they go to trial, that this man actually has a defense and a very good one, and so will involve the defense in the grand jury process with them, then it works. It doesn't work, though, and probably we can hear examples of 8, 9 times out of 10 now, if all the prosecutor's doing is putting in triple hearsay and not giving the opportunity for the defense to access the grand jury.
All right. Well, I actually want to pick up on one of the themes you mentioned, and that is a focus on grand jury witnesses, because I think a lot of attention is paid to the powers and prerogatives and protections of the grand jury vis-a-vis targets of grand jury investigations. But what would you say, Gina, about the interest of witnesses before the grand jury and how those interests are impacted by how the institution operates?
Sure. Well, first of all, I wanted to echo everybody else's sentiments and say thank you for the opportunity to be here to speak with you all today. Well, if you are a prosecutor, I think the interests of witnesses, you don't really think about it as much, perhaps, as you should. If you're a fair prosecutor, if you're an even-handed prosecutor, if you're not overzealous, if you understand that you should go where the evidence leads you, then maybe you are more respectful of witnesses. You understand that you won't be able to make your case without members of the community coming forward to assist you if they're an eyewitness to a particular event or if they have knowledge of documents you're interested in. You understand that it's a process in which it's going to be very scary for that witness. And so it's really upon you, if you do have integrity, to sort of do a little bit of an explanation of, this is why you're here, generally. You have a right to have an attorney. Would you like to have an attorney? And what I used to do is if I knew certain witnesses were going to in advance, because you know your case, right? You know your case. You should know your case before you just throw witnesses into the grand jury. You can anticipate if there are going to be some witnesses who may need counsel, and you just work with a public defender or you work with someone to get them counsel in advance so that the process isn't as disruptive as it can be for your average witness. So, and there are plenty of prosecutors, I think, who exist who are fair and who have integrity, who are not overzealous, who, as Carol said, they follow the evidence where it leads them. If I'm going to be provocative and play defense attorney for a minute, I want to change your question, if I may, which is, how are witnesses' interests impacted by the grand jury and the way it operates too? How are witnesses' rights impacted by the way a grand jury operates? And so here are just a few rights, if I want to be a defense attorney for a second. You have a right to be surprised at your dinner hour with a subpoena by a federal agent, or when you're feeding your kids, or when you're trying to get your elderly parents who are in need of wheelchair assistance, bathed, fed, and, to bed. You have a right to counsel if you're savvy enough to understand the advice of rights form that may or may not be attached to the subpoena you received, because the agent may have forgotten to, or may have disconnected it, or it may have fallen off. So if you're savvy enough, you have a right to have counsel present to represent you. If you're not savvy enough, you have a right to show up when the government tells you to show up and to answer the questions that they ask you in the way in which they ask you without understanding fully what's going on. If you have counsel who's there, that counsel has a right to beg, plead, wheedle, cajole, and ask the prosecutor for a sufficient amount of time to meet with you, to prepare you to appear in front of that grand jury. And as Carol mentioned a minute ago, you have a right to sit outside of the grand jury room and hope that your client is savvy enough to say, gee, I think I really need a break and I need to go talk to my attorney. So those are some of the rights that you have if you allow me to change your question if you're a witness. You don't have a right, as I know Jerry's going to talk about, to review your transcript or any recordation of what it is that you said, unless, of course, the government decides they want to use you as a witness for trial. And, of course, most fair prosecutors give you an opportunity to review your transcript before you testify, partially because it benefits them to sort of make sure there are no inconsistencies in what you've said previously to what you're saying now. So that, if you allow me to change your question, that's how I would answer that question. So,
Absolutely, absolutely. So, and I think that this is a perfect segue into what I want to ask Jerry, because I think despite the recent attention being paid to the grand jury in the United States, as Ted mentioned, in the wake of Ferguson and Staten Island, there really is a long and storied movement for the purpose of grand jury reform that's been led by the defense bar, and NACDL has certainly been a leader in that movement, the American Bar Association, and others. So, Jared, can you give us some insight into how these reform efforts have developed, and then also identify some of the leading proposals, and perhaps give us examples of where they're actually working in practice in various jurisdictions?
Sure. I want to thank my co-panelists and Roger for being here. I, as a young lawyer in a federal case, believed my client totally was innocent and knew that he was under investigation by a federal grand jury in New York. And I went before the sitting Part 1 judge, the famous Marvin Frankel, who had written a book with Gary Naftalis on the grand jury, and said, Your Honor, I want my client to testify in that grand jury. I think what he has to say is not only accurate, but will cause the grand jury to not indict him. And Judge Frankel turned to the prosecutor and said, why not? Why not? What do you have to lose? And the prosecutor says, we don't think it's appropriate at this time. And the judge said, I can't order you to, but I'm begging you, run a fair process. Let the grand jury hear his client. And the prosecutor said, sorry, Your Honor. And the judge turned to me and said, I'm powerless. It's lawless. You have no rights. And from that moment on in my life, it just seemed to me that the workings of a federal grand jury, and putting aside a totally fair, unbiased prosecutor who wants to be inclusive, putting that aside, which quite frankly I haven't run into that many of those kind, it is a system, as the then chairman of the House Judiciary Committee, Henry Hyde, said, the grand jury is a total captive of the prosecutor who can indict anybody at any time for almost anything. That's Henry Hyde, a conservative Republican, when he was head of the House Judiciary Committee. And those words, I don't really believe can be disputed. And so many years ago, NACDL and the American Bar Association started to consider reforms, and we put together a commission that consisted of two former number twos in the Department of Justice, Arnold Burns and Larry Thompson. We put together former United States attorneys, Anton Valukas in Chicago and Tom Dillard out of Tennessee, law professors, trial lawyers, and we considered for 2 years how it could be changed so that it indeed could be serving the constitutional function to protect the accused. And we came up with a list of reforms, trying to get a statute passed that would overrule what I call the tyranny of small decisions from the Supreme Court of the United States, which has allowed illegal evidence before a grand jury, hearsay evidence, non-competent evidence, no jury instructions, no anything. You don't even need evidence in order to have a federal indictment. And the Supreme Court not only decided that all of that was okay, but it went further in an opinion by Justice Scalia, which said if there's a fair trial, you can't even ever look back at what the grand jury did or didn't do, or what they heard or didn't hear. So this system, lawless as it is, could be reformed. And we got together and we came up with a Bill of Rights for the grand jury. But primarily, they revolve around certain really fundamental rights. And that is the right to testify, the right to have the prosecutor present exculpatory information, and the right to counsel in the grand jury. Why? This is certainly one of the most important moments in a criminal prosecution, and the right to counsel exists everywhere else. Why not in the body that is considering the charges? And that's not for the lawyer to say anything, but just to be alongside the client, and if the client has a question, or to tell the client to bring out information that's in his or her interest. These just fundamental rights are the basis of what we call the Bill of Rights, and there are several. And many states have implemented some of these rights, some of them, like New York, all of them, in Massachusetts, all of them. But at least a dozen states have the right to counsel in the grand jury. And the republic is not falling. The crime rate in New York is the lowest it's ever been, or at least in the last 40 years. This is not causing problems. Prosecutors are not complaining about it. So if you look at it, in the federal grand jury, of course, there's no right to testify. In New York and many other states, the defendant simply serves a notice, and he has the right to testify and the right to have counsel. In the federal arena, of course, counsel is prohibited. In the federal arena, Justice Scalia's decision determined that the prosecutors do not have to provide exculpatory evidence. In New York, the prosecutors, if you're directing them to something and it's exculpatory or exonerates the defendant, they have a duty to present it to the grand jury. In addition, in the federal arena, it could be hearsay, it could be illegal evidence. In New York, it must be competent evidence. You can't have hearsay in the grand jury. Now, of course, in the federal system, the prosecutors supposedly must present a prima facie case, but there is no mechanism that exists to challenge the fact that they didn't present a prima facie case. In New York, you can have a motion to inspect the grand jury minutes. The trial court must read the grand jury minutes, must decide whether a prima facie case has been made out with competent evidence. And then the judge has the right, if not, to dismiss. The judge also has the right to reduce the charges. If a felony wasn't made out and it's only a misdemeanor, the judge can reduce the charges. These essential reforms have the aspect of allowing a true, fair process. If you can't convince the prosecutor that the case shouldn't be brought, perhaps you can convince the grand jury. And Justice Kennedy, some years ago in the Gentile case, talked about the time between an arrest and a trial is crucial for a defendant. First of all, in the internet age, of course, once you're indicted, that's it. It's there forever. Whether you're acquitted or not, it'll always be there for somebody to find out. And what New York's procedures and other states afford you is the opportunity to try to, in effect, litigate before a trial the charges or whether there should be charges. And you can put your client in front of the grand jury, go there with the client, as I have done on more than 10 occasions, and have the grand jurors look at the facts. Because unless the prosecutor wants to put in facts that undermine their case, the grand jurors are never going to be really acting as their historic function should be, which is to protect the defendant. So these procedures, as they have in New York, allow a grand jury to really say to themselves, is this a case that we want to vote? And just incredible numbers of cases now where defendants testify, the grand jury is actually deciding something rather than just putting a rubber stamp on what the prosecutor wants them to do. So we who are part of this report, and to this day, I see these names, some of the great trial lawyers in the country, like Ted Wells, who's the head of litigation at Paul Weiss, and John Kecker. These are, people who are very thoughtful, who spent a lot of time. And with a statute, we could change the federal system to actually make it somewhat fair.
So I guess, on that theme, is it just a matter of political will? I think many could articulate reasonable responses to some of these proposals, and certainly I think a debate around the proposals makes sense. And so, for instance, you mentioned the proposal related to transcripts of witnesses. And certainly one argument I've heard in response, and I think Jerry and I have talked about this, and we were on a radio show one time discussing this, is that, if you give the transcript of the testimony to a witness in an organized crime context, that would allow the higher-ups to monitor what the folks on the lower rungs are saying in the grand jury, and thus give them the opportunity to obstruct justice, and that's a real concern that many in the prosecution community would cite. Is there a response to that would, I think, facilitate our move from the policy discussion to making it a reality that witnesses would receive transcripts? What's the rebuttal to the Justice Department position on that?
Well, I mean, I could say that, the rebuttal is that the witness has a right to go out and tell anybody what the witness testified to. And the witness could tell his lawyer could tell anybody, and that's done all the time. What's the difference between the First Amendment right to speak about what occurred in the grand jury and actually having a transcript of your testimony?
Yeah, I agree with you, Jerry. And the one thing that is really insidious, and I saw this happen when I was a prosecutor, and I've seen it happen as a defense attorney, is when a prosecutor recalls your client as a witness, brings them back to the grand jury, and then you should demand. I wouldn't put a witness back in the grand jury without, even if the prosecutor won't give me the transcript to keep, without having the witness at least be able to read the transcript whenever she wants to, before she goes into that grand jury room again, because then you get there's a whole federal statute dealing with inconsistent statements before a grand jury, and the easiest way to have inconsistent statements is if you just say something a little bit differently than you said the first time. It's not a falsehood, you didn't mean to mislead, but it's only right and fair that you should have it in those instances. And I agree wholeheartedly with Jerry that you have the right to go out and tell anybody on the street what you just said in the grand jury. The grand jury secrecy rules do not apply to witnesses, or for that matter to the defense attorneys. Now, it's not always the smartest thing to do. If, as counsel, I almost always advise my clients not to speak about their testimony, but I also do what Niki did, and that is I sit there and I require the client to sit down and talk with me and while it's fresh in their mind, and take notes. I shouldn't have to do that. I should be able to get a transcript, unless it is the kind of case that you just referenced as an example. I understand, my safety would be an issue too, and my client's safety would be an issue too in an organized crime context where you do have to be careful there. So you are, I would think, in the most part, limited to just writing down everything your client said in the grand jury afterwards.
And Roger, if I may, why couldn't there be in sort of an organized crime case or some case that presents an issue of safety, sort of one of the two possible sort of following mechanisms? Maybe kind of a limited release or some sort of provision that restricts the ability of the attorney to release, thou shalt not share this transcript with anybody beyond XYZ, or there's a delayed release. I mean, if you're concerned in the midst of your investigation about maybe somebody who's a violent or a dangerous person finding out with particularity what witness X said, right? Because we can all do our best to do copious notes and get the client's download or debrief of what transpired, but the client doesn't remember everything that transpired. I mean, that's what the court reporter's there for, right? So, I mean, couldn't there be something where there's sort of either limits on to whom it's released or the circumstances under which you're allowed to review it, like you have to come to the U.S. Attorney's Office, for example, and review it, or a delayed release, but at some point an opportunity to see your transcript. Or as Carol said, particularly if you're going to recall someone back to the grand jury, you've got to be given the opportunity to review your transcript, but maybe you come to the U.S. Attorney's Office, you look at it, you give it back. I mean, something. That seems to me to be fair.
Yeah, and Roger, I'd like to touch on the much broader issue which this raises, which is grand jury secrecy in general. because there is, as Carol says, a legitimate role for grand jury secrecy when there's an investigation ongoing and your client's reputation is at stake and so forth. But the federal rules about grand jury secrecy go so far beyond that rationale. I think you could really have a very positive benefit from, for example, in New York, right, you can have some petition to inspect the grand jury record. If you had a much more generous sharing of grand jury materials, sharing of the transcript after the charges are brought, that would shed a lot of sunlight on what's happening inside the grand jury room. The way the federal courts work, the prosecutor has access to the entire grand jury transcript, but the defense only gets parts of the grand jury transcript insofar as the prosecutor decides they are exculpatory, which is required by due process, or usually the night before a prosecutor witness testifies, they will give the grand jury transcript. That's a statutory right. But the rest of the transcript never shown to, never sees the world for the most part.
You know, Roger, one thinks about some of the cases that we've had in recent years and whether these reform measures could have prevented them. You think of the cases like the Duke lacrosse case, where the prosecutor, in an act of reverse racism, pandering to the black community, had 3 players from the Duke lacrosse team indicted for a rape where there was exculpatory information not presented. It led to, of course, the disbarment and jailing of this prosecutor. You know, there's a great quote from Judge Hawkins of the Ninth Circuit, just talking about that case and due process. He said, if you described what happened in this case to a stranger and didn't say what country it happened in, you wouldn't think the first one would be America. And, you know, if you had procedures where the defendants had a right to testify, where the prosecutor had the right, had the duty to present exculpatory information, cases like that and maybe Senator Ted Stevens may not have occurred at all. So this is an important reform issue, which to me, and to a lot of the people on this commission, just seem like common sense.
So I guess on that topic of exculpatory evidence, because you certainly hear the response, well, certainly the Supreme Court, as Niki alluded to, has said that the grand jury is not designed to be a mini trial. And so everything we're used to in the trial doesn't necessarily translate into the grand jury process. And the need to present exculpatory evidence would fall into that category under the court's reasoning. But DOJ would say, look, in the U.S. Attorney's Manual, it says right here, you have to present exculpatory evidence. And so we hold our own prosecutors to our duty, to their duty to present exculpatory evidence. And if they don't do it, they can be disciplined or fired, even though it's not a constitutional
Roger,
right. What's the response to that?
The United States Attorney's Manual says this provides no rights. You can't go to court and say, look at the United States Attorney's Manual. They have to do this. Because by definition, it is just guidance to federal prosecutors. And they don't do it. They don't have to do it. There is no discipline. I don't think you could name one case where a prosecutor has been disciplined for failure to put exculpatory information before a grand jury. It's just not done. And indeed, they don't have to, and they don't do it.
Well, I mean, I think, you know, it's sort of hard to, maybe to the sort of point of not really understanding or not being able to see with clarity what the government is doing sometimes. I mean, theoretically, prosecutors are supposed to be referred to OPR, the Office of Professional Responsibility, if they engage in unethical conduct associated with prosecuting individuals, to finish the hypothetical. But you never really hear about it. It's not sort of publicly announced, or you don't hear what happens to these folks if, in fact, there was a disciplinary procedure that happened and what the consequence was. Maybe they just get reassigned somewhere else in the office. But so, you know, there is theoretically some sort of mechanism, albeit you're right, absolutely no mechanism to challenge in court a prosecutor who behaves unethically, who indicted someone despite evidence that was exculpatory. But ostensibly, OPR exists to investigate these matters,
Well,
theoretically.
but I don't even think, Roger, that the United States Attorney's Manual is something that must be done. I think it's simply as guidance. And I've never heard of any prosecutor worried about, what's in the United States Attorney's Manual. I've brought to their attention on many occasions, you can't subpoena a defense attorney to a grand jury without a whole level of review and all that. They said, well,
Yeah, I mean, I would agree with that. The U.S. Attorney's Manual is really, it's a manual of practices. It's not an ethical, body of ethical rules. And the problem, I think, I would actually like to get away from the idea that it's about prosecutorial abuse, because there are a lot of good prosecutors, there are some bad prosecutors, but to me the problem with the grand jury is that a perfectly ethical prosecutor acting within the legal rules can get an indictment legally and properly by presenting third-hand hearsay that does not lead to a meaningful review process by the grand jury. So to me, it's more that the rules create a relationship between the grand jury and the prosecutor, which virtually ensures that the prosecutor will have an almost overwhelming voice in the grand jury's decision-making process. And the question is, how can we address that issue, the structural issue, in the federal system?
I would just note, too, that, again, I'll go back to what I said earlier about if you just eliminate the grand jury, what's your alternative, and what are you left with? So let's just address one issue that the next panel is going to be addressing in full, and that is, we've been talking about protection, shields for the accused, and in the cases, the Ferguson case and the Staten Island case, you're talking about police officers who were the defendants, or were the putative defendants. So let's look at it from a different perspective. Let's look at it from the perspective of the victim and of the community, and say, we're all defense attorneys here, so we're so focused on the defendant having rights to be protected and to be shielded from an overzealous prosecutor. Well, the flip side of that is that sometimes, not just in situations like in Ferguson and Staten Island, but I've saw it as a prosecutor where a grand jury gave my police officer a standing ovation in a case. It wasn't the police officer; he was the burglary victim, because he went to the top of the steps in his house and he pointed a shotgun down in pitch black residence, no lights on, and blew away a young man who was burgling his house, and they gave him a standing ovation. Now that's the grand jury, and they heard the circumstances, the frightening circumstances for that homeowner. They made that decision. As a prosecutor, I probably also would have made the decision on my own not to prosecute him. But what do you do in a situation where you have none of these rights by counsel for the putative defendant, or even for the victims? And when we're talking again about Ferguson and Staten Island, who had the voice in the grand jury for the victims in those cases? There were people who testified. They got the different perspectives of the various witnesses. So what's the problem with using a grand jury in those cases? What was the problem with the grand juries?
Well, I could give you a few problems.
No, I'll tell you what the biggest problem was, and that was that it wasn't an independent prosecutor. Remember I said earlier that that's the linchpin, that's the thing that makes it either a success or a total disaster, where if you have a prosecutor who's hell-bent on introducing inadmissible evidence that he knows or she knows will be inadmissible at trial, or they're hell-bent on not getting exculpatory evidence in, they're just going to put their one side in, they're going to taint it with all sorts of speculation, hearsay, and personal opinion, which you can give as a prosecutor. You can give your personal opinion, but there are cases about how you should not be giving unsworn testimony as to the facts. Well, unless we have transcripts after the fact, we don't know whether these prosecutors have given unsworn testimony about the facts that are not already before the grand jury. And so with my thought is, what do? You get an independent counsel in those scenarios where the defendant is tightly involved with the prosecutors, where it's a police officer, where it's another prosecutor, where in some instances it's a member of the bar, a private defense attorney, whom everybody loves. I prosecuted one such man in Washington, D.C. you old enough to remember this, John Shorter. He was a criminal defense attorney, very popular. And I didn't do the grand jury. I was handed the case after he was indicted, and I prosecuted it. But if I'd been the prosecutor handling the grand jury, I liked him, you know. I would not have liked to have seen him indicted if we could have avoided that. But I certainly prosecuted him and convicted him. But that is, I think, a separate issue, I guess, that we could go into for another hour. But that is absolutely makes a difference in a case where you have all these concerned about the rights of the witnesses and the rights of the putative defendant. It's also the rights of the community, which is why I like very much the idea of maintaining a grand jury and getting these reforms through, or at least, absent the reforms, develop close relationships with the prosecutors to get your client before the grand jury, or to get, if you want them to testify, and to get as much information before the grand jury as possible.
Well, so certainly one reform that has been mentioned recently is a reform that was cited by or proposed by Judge Littman in New York, I guess in his State of the Judiciary address, and in certain circumstances would have a judge present in the grand jury proceedings. So, that, along with some of these other reforms, one could argue really makes the grand jury look a lot like a trial. And
what's wrong with that?
And so and Jerry would say, what's wrong with that? So that's the question actually I want to pose to the panel. Well, what is wrong with that, if anything?
Well, particularly as Justice Kennedy said in that Gentile case, I mean, if you're going to be charged, it's going to affect your life forever, even if you're acquitted. So why not, at the earliest stage, allow some process where a grand jury could act like they were supposed to act to protect the defendant if the defendant is worthy of protection? These grand juries, for instance, the Staten Island grand jury, I mean, it's not really talked about much, but the DA in every county in New York has detectives, senior detectives, working in their office. They have what they call the DA's squad. Those are policemen. So this is not just the district attorney's office. It's a district attorney and police office. And so the notion that that district attorney could be totally fair and impartial and be seen as fair and impartial, it's just not possible. You have a tape here where some man is saying, "I can't breathe," over and over again. There's 5 police officers, 4 of them are on him, and the police officer is not arrested. Now, think about that. A man is killed. He is being choked. He's saying, "I can't breathe." The person who's choking him is not arrested. That's a special tip of your hat to the police. An individual in that circumstance would have been arrested. Yes, he could testify in the grand jury, and he could try to have his witnesses testify on his behalf, but he wasn't even arrested. So,
but Jerry, how is that going to change it? I don't think you're advocating the elimination of the grand jury.
No, I'm saying in that situation, I'm agreeing with what Roger said about Judge Littman's suggestion, and Governor Cuomo even had another suggestion, that those district attorneys who deal with police in every single case they have cannot be relied on and should not be in a position to be investigating, in effect, themselves, because they are law enforcement. The police are in their office. The police are involved in every case. So it's either an independent person taking on this investigation. And when Judge Littman said a judge should be in the grand jury, it occurred to me, whose grand jury is it? Is it the court, or is it the prosecutor? I mean, people thought that was heresy, to actually have a judge go to the grand jury. It's an interesting idea. The way it shouldn't be done is the way it was done. It just can't be that a district attorney so involved with the police in that community be investigating the police. It's investigating themselves.
Well, so what about that? I mean, given the significant burdens associated with criminal jeopardy, as Jerry alluded to, early in a case, you can never get your reputation back. Sometimes you can't get your passport back. You have to hire a lawyer. You may lose your job. Your social network may be disrupted. Given all of that, does it make sense to have something that looks a lot more like a trial with a lot more process due to the accused individual earlier in the process, despite the notion of the grand jury that we've held to for centuries?
Yeah, I think it does. Whether that's in the secret proceedings of the grand jury or not is one of the questions, because you could also have a much more meaningful preliminary hearing process. I mean, one of the things that I think is particularly pernicious right now about the grand jury, the notion, the legal fiction that the grand jury is doing a meaningful review of the evidence, is that grand jury indictment is deemed to definitively establish probable cause. So what that does for the defendant is, once you're indicted, that's the foundation for arresting you. That's the foundation for eliminating any right you have to a preliminary hearing. That is probable cause for pretrial detention, and that could be probable cause for any due process rights you might otherwise have about losing your job, if it's a state job. So, yes, we need a much more meaningful pretrial screening mechanism, and the question is, what should that be? And maybe the grand jury needs to be more meaningful, and there needs to be an actual judicial hearing. I would be a little reluctant to have the judge in the grand jury, both because that's still a secret proceeding, and I think it would be problematic to have the judge involved in investigating. That's really very much inconsistent with the judicial role, to be leading an investigation, a secret investigation. But there's a middle ground. You can say to the grand jury, rather than have the prosecutor here to answer your questions about your powers and your role, you can ask those questions to the judge. The judge gives you the initial instructions about what your powers are, and if you have questions as the case goes along, you may pose those to the judge, and he or she will answer those.
So we've talked a bit about targets, we've talked about witnesses, we've talked about prosecutors, we've talked about judges vis-a-vis the grand jury. The one group I think we haven't paid much attention to would be the grand jurors themselves. And if you remember back to your freshman year in college when you read Alexis de Tocqueville, Democracy in America, you remember that he observed that the American jury system was what he called a free public school. He really thought that it was a great source of civic education for the citizens who were called to serve on juries. And given the structure of the grand jury, its role in our system, and the fact that grand jurors serve for lengthier terms, they get exposed to usually many different matters, is there anything that we can do to reform the grand jury system that would provide a greater benefit to the grand jurors themselves, who are giving of their time and energy to participate in the process? How can we enrich the process for those who participate as grand jurors?
Well, I don't think we have to. I think many of the reforms that we've discussed would enrich the process enormously, especially the idea of allowing targets to testify as a matter of right, if they want to. That's a pretty dangerous path to go as a defendant, a putative defendant, a target in a case, to actually go in front of a grand jury without your counsel, for at least at this juncture. We don't have the right of counsel in the grand jury in federal cases. But other ways to meaningfully involve the grand jury in this civic function, which as a defense attorney, I'm not supposed to give a hoot about, all right? All I care about is that my client not get indicted. But the one thing you could do is what, again, I think I mentioned earlier, I did as a prosecutor. I drew the grand jury into the actual case. I would talk with them about the case. All of it was, part of it was on the record and part of it was off the record. This is before the requirement that it be on the record. But one of the things I also did, and I know many prosecutors don't do this anymore from what I hear, I asked the jurors to pose questions themselves and to have them actually ask the questions, not just run it by me first and then I would ask the question. And so that would get the jury more involved. And there's no prohibition on jurors asking questions, and just the prosecutors don't do it enough. So I think one thing to consider is that the government needs to get a little bit more, they need to be a little shaken by some of the recent developments, and need to take into account that that if we are going to have this community body, can be an investigative body that should be mindful of the presumption of innocence and should hear more of the story than just what's being presented to them by the prosecutor, yet not be a full adjudicatory hearing, not be a full trial before a trial, then we need to get prosecutors' offices, federal and state, to have the heads of those offices, the district attorneys or the U.S. attorneys, to really make a commitment to get involved in what their assistants are doing, and to find out and to make sure that they give them the training they need, especially the new kids on the block, to give them the training they need about the importance of this institution and the benefit to the office and therefore to the people they serve, the public. It's United States versus John Doe. It's not the victim versus John Doe or the prosecutor versus John Doe. To involve the grand jury more in the process, instead of just being a prop, as I said earlier, to all the subpoenas and the third-hand testimony that they're hearing, and to actually present evidence to them that may not be as helpful to your case, but you know is going to come in at trial, so you may as well get the feedback from the community right now about that evidence. I can remember getting situations where I would withdraw cases from grand juries. And we haven't discussed that here, but cases would be withdrawn, just as the Ferguson and the Staten Island cases were withdrawn, but on a not so infrequent basis. When you start getting into the white-collar crime area, and when you start getting into some dropsy drug cases where it really wasn't clear at all what happened, I would withdraw it. So you want prosecutors to have that discretion, but I sometimes withdrew cases as a result of the grand jurors saying to me, it's not going to cut it. And that's what they're there for, that not just to be your rubber stamp on the true bill, but to give you the feedback and to give you the certainty as a prosecutor, again, assuming you're ethical and you're competent as a prosecutor, that you actually do have a case that is worthy of prosecution, and go forward from there.
You know, I don't know if people remember Judith Kay, who was the chief judge of the New York Court of Appeals. She was instrumental in many changes in our criminal justice system, but one is she put together a jury project and had a group really consider how jurors and grand jurors are treated in our system. And quite frankly, it was shocking how they were sort of used and not really respected and not really educated. And a lot of changes came in, including the fact that everybody has to serve, including lawyers and judges, and she ended up on a jury herself. But I always say, as a defense lawyer, I would like every prospective juror to see 12 Angry Men. Well, she didn't institute that, but she did institute, you know, a video for jurors that really talk about their role. And, you know, I think judges around the country impanel grand juries, and they don't really think about education of the grand jurors as to what their historic role is and what they should be looking at and what their rights are to ask questions, to ask for witnesses. You know, if there could be instituted some national change on how we select grand jurors and what we tell them, I think it could serve some useful function.
Now, I know we're winding down, and I did intend to have questions from the audience. I'm actually going to take up a question that was posed by a member of the audience before the panel started, and that is the current president of NACDL. Simon, he mentioned to us the notion that the Fifth Amendment seems like a barrier. Certainly for those who are in favor of the abolition of the grand jury on the federal level, it's clearly a barrier. But for those interested in reform, I think sometimes they've seen it as a barrier as well. And he asked a simple but I think profound question. How do you engage in reform given the Fifth Amendment and its lack of specificity as to what a grand jury is? How do you actually get some of these reforms put into place? So what are some of the mechanisms we can use to actually implement the reforms outlined in the NACDL report and elsewhere?
Well, one of the things that you'd have to do, I think, is to pass legislation that provides the right of a defendant to testify, to demand to testify, the right to counsel in the grand. All of these reforms can be part of a statute that we almost had introduced when we filed this report. We had a big press conference, and there was a congressman, I forget his name exactly, from Massachusetts, who said he was going to introduce legislation to make these reforms law. I don't think without legislation you can really alter the situation. I may be wrong about that, and certainly, the court hasn't said, but simply voting procedural changes might not do.
I should know this, and I don't, but I do not think that the rules address who can and cannot be in front of the grand jury.
You're correct. They don't. I think that's
They
right,
don't.
Gerald. They don't.
Cannot
Right.
be in front.
You're right.
In
In
what
of the
sense?
grand jury when the
Rules
grand
of
jury is in
procedure.
session.
No, yes, it does. The Rule 60.
Well, 60 says
no,
that
but, yeah.
what has happened there has to be maintained in confidence
Right.
by the
No.
prosecutors.
No, it also says, these are the following people who may be in the grand jury
Okay,
when it
all
is
right.
in session. So you
All right.
would have to amend Rule 6E, and then you might have to do it statutorily. The problem is that under the body of Supreme Court law right now, as it stands, the Williams decision is a big obstacle to sort of changes that come from within the court systems. In that case, the 10th Circuit tried to, by internal rule, court rule, say that the grand jury must hear exculpatory evidence, and the Supreme Court said, no, the courts cannot, by rule, change the procedures of the grand jury because it's an independent institution. Any changes in the traditional format of the grand jury must come from Congress.
Well, see, that's nuts.
Yes, it is
to
nuts.
say that the courts can't say you really ought to be giving
Yes.
exculpatory evidence to, because how's that changing the procedure? But when you look at the 10 different recommendations that were made by the ABA and NACDL back in 2000 when Jerry was on that commission. The first one is the presence of counsel for grand jury in the grand jury room. Now, that's not going to happen except by statute, right, Jerry?
I agree.
Okay. Disclosure of exculpatory evidence to the grand jury. Why can't Eric Holder or whomever's Attorney General say, and every U.S. attorney and every district attorney say to his or her troops that thou shalt put exculpatory information before the grand jury?
They
And
could, but will they?
Well, but no, but what more? I mean, again, you have to. It all comes down to, is the person ethical or competent as a prosecutor? Because the case is indicted later on. The Ted Stevens scenario happens, right? If those prosecutors, and I know some of them, and they're basically very good people, but what happened there in part was that they were scrambling after the indictment to get things together, and I'm not going to give anybody a pass for what happened there. But oftentimes that is the scenario, isn't it? That prosecutors don't necessarily even know what they've got in the big white collar cases until they indict it, then they go into trial and they're getting ready for trial and they go, oops, I see this, and sometimes they don't disclose when they should, and then they should be penalized for it. The case should be dismissed. No ifs, ands, and buts about it.
But you're
But
right.
if you force them
all
to
of
face
these
this-
reforms could be
Policy.
made if the Department of Justice
Sign on to
decided
it, yeah.
that's what we want to do.
Just about all of them.
And they have in some of the provisions of the U.S. Attorney's Manual. Some of these things are in there, but they're not required. And that certainly nobody has said from on high a defendant shall have the right to testify, and our assistants are going to allow them if they choose to.
Right.
So it could be done without legislation, but the only way it could be absolutely enforced is through legislation.
So are you saying, Jerry, that all of these 10 provisions, you think the only way they can be enforced is via legislation?
Yes.
Oh, I don't think so. I think
That's, yeah.
yeah.
I-
I don't think so. Well, what you're saying is that without it being legislated, if it's just departmental policy of
They
the
could do
Department
it.
of Justice, well, but if it's just departmental policy, then how do you enforce it as a defense
I
attorney?
have no way of making them do it
Yeah,
unless
right,
I have
see what you're saying.
legislation.
Right.
All right, so in our final moments, I wanted to try to perhaps segue to the next panel, right, which is going to focus, I think, more explicitly on the issues related to the Ferguson and Staten Island grand juries. And so I'm going to ask each of you to identify, that reform or cluster of reforms that you think might have made a difference in those cases. A good friend, a fellow law professor, she teaches at Georgetown, has written, I think, a provocative piece. Kristen Henning is her name. Has written a provocative piece pointing out that as far, at least as far as the Ferguson grand jury goes, there were some of those reforms present there. I mean, the defendant did testify in the grand jury, and the prosecutor did present, well, I guess if the prosecutor presented all the evidence, some of it may have been exculpatory as well. And there are many who would be in favor of grand jury reform who are dissatisfied with the outcome in the proceedings in Ferguson. So I'm interested to hear from the panelists what particular reforms might have made a difference in those cases, or more generally in cases involving police defendants in the same vein as Ferguson and Staten Island.
Well, go ahead.
No, the one and only reform I can think of that might have made a difference would have been something that's not on this list, and that is to have, in any case, as we said earlier, in which it's somebody in the police community who's under suspicion, and I mean any case. I don't mean just cases in which there's concern about racial bigotry, but in any case in which there's a police shooting. You should have either a stable of reputable, lawyers, either local or national, available to you, or you should you should appoint, and you being either the district attorney or her superior within the state, if it's an attorney general system, or the U.S. attorney in the district, or in consultation with the Justice Department. I'm not big on, even though I was appointed by a judge in both cases in which I was independent counsel, I was appointed by a court, a three-judge court. I'm not big on involving the judiciary in appointment of independent counsel. I think that a district attorney, the governor, they have to take political responsibility for what's happening. So they need to be the ones to make the appointment, whoever it is, of an independent counsel. And I'm real fine on the federal level with Congress being involved too, as it was way back with Watergate, when Leon Jaworski, Archibald Kuckes, and then later Leon Jaworski were appointed as the Watergate prosecutors. Congress was involved when that happened. They didn't have, it wasn't, advising consent of the Senate or Congress, but they just held hearings and they talked with those men before they assumed their offices. And that gives a buy-in of the legislature to those things. You could do that in the state level as well. But I'm suggesting a process where you actually have that stable or a person identified on January 1st of every year in a community, in a state, even at the Justice Department, who'd be available to step in if needed. And if you don't want to identify them in advance, which I think is a good idea, then identify them when it happens.
I pretty much agree with everything that was just said, but I think that there's a dirty little secret that people in the system know, and that where a police officer's conduct is in question, such as Ferguson or Staten Island and the district attorney really doesn't want to bite the bullet and say, I don't want to bring these charges, they put it in the grand jury in a way where they know what's going to happen. This is using the grand jury to cover their butts and, in effect, to launder their own decision, which they've already made. And that problem of them being in that position where the community does not have the real feeling that this is an independent process that's really looking to see whether a charge, that is a major problem. And whether it's Judge Lippman's decision or a special person on duty all the time who will take those cases, we can't go on the way we have with the DA who's so involved with the police making that call.
Yeah, the thing that's interesting is that really the Ferguson case, Staten Island case, are a unique subset of grand jury cases that are in many ways so atypical that many of these reforms don't really go to them. And I think that's why we're talking about that fundamental conflict of interest issue, which is really the one that has to be addressed in the police brutality cases.
Gina, I'll give you the last word.
You know, it's interesting. The one thing I was trying to see if I was recalling this correctly, I thought I recalled in the Michael Brown case that before, in a few days immediately after the incident happened, there were leaks that were happening to the media about Michael Brown and whether or not he was involved in an incident. Did I remember that correctly,
absolutely.
Jerry? And
So
it was sort of on CNN.
police tapes being shown on national television
Exactly,
of him
exactly.
in the store.
So
Right.
I don't think this is directly responsive to your question, but I was just wondering in those particular cases, and I don't know if it's a case in which it's just restricted to policemen involved in shootings of citizens, if there needs to be something to sort of protect the rights of the victim a little bit better. I mean, I think from my perspective, I think that there was a little bit of, to your point, Jerry, kind of a poisoning of the well. So even before the grand jurors were even selected in that community, you've been seeing CNN, you've been hearing about the victim, you've been sort of
Absolutely.
playing to stereotypes and all those things that were, you know, unique perhaps to that situation, maybe not so unique, right, Jerry?
Yeah.
I don't know. That would be the one thing that I would sort of ask for in those particular kinds of cases, something to kind of address the rights of the victim a little bit more, like a right to have evidence presented about them that's a bit more complimentary, for lack of a better phrase, or but more even-handed, to be more accurate.
Okay. Well, this has been a terrific discussion. I want to thank Niki and Carol and Gina and Jerry.
And thank you.
Oh,
Hey,
no,
Roger.
no. It was just a pleasure to be here, and it was such an enlightening and engaging discussion. And thank all of you out there for your attention. And with that, I believe we'll prepare for the next panel.
Good afternoon. Our next panel will be moderated by Angela Davis, Professor of Law at the American University Washington College of Law, where she teaches criminal law, criminal procedure, and criminal defense. Professor Davis is the author of Arbitrary Justice, The Power of the American Prosecutor, which won the Association of American Publishers 2007 Professional and Scholarly Publishing Division Award for Excellence in the Law and Legal Studies. Professor Davis is also the co-editor of Trial Stories with Professor Michael E. Tiger and co-author of leading textbook in the area of criminal law. A graduate of Howard University and Harvard Law School, she serves on the Board of Trustees of the Sentencing Project, the Southern Center for Human Rights, and the Peter M. I hope I pronounced this right. Let me just spell it. CICCHINO, Social Justice Foundation. She served as the executive director of the National Rainbow Coalition from 1994 to 1995, but among the criminal defense bar, she is probably best known for her distinguished tenure at the Public Defender Service for the District of Columbia, PDS, where she worked for 12 years, ultimately serving as both deputy director and director. Angela, we look forward to your panel.
Thank you. Good afternoon, everyone. I'm very pleased to be moderating this afternoon's panel on equal justice and the grand jury, achieving racial fairness. The purpose of the grand jury is to decide whether an individual should be charged with a crime. And the idea is a democratic process that brings ordinary citizens to the decision-making process and to act as a check on overzealous prosecutors and police officers. Grand jurors basically decide whether there's probable cause to believe that a defendant has committed one or more crimes and whether an indictment should be returned for those charges. They are constitutionally required in federal cases, and about half of the states require grand juries in felony cases. But grand juries have long been criticized as a tool of the prosecutor, and many consider the process almost pro forma, as grand juries almost always return indictments. But the failure of the grand juries in Ferguson, Missouri, and Staten Island, New York, to indict the police officers who killed unarmed black men has raised other questions about the grand jury. Questions about racial fairness, and particularly in cases involving police officers who kill people of color. So we're going to address those issues this afternoon and more during our discussion of equal justice and the grand jury achieving racial fairness. And we have a great panel of experts that are going to discuss these issues this afternoon. And so I want to start by introducing them, starting with, to my far left, your far right. We'll start with, one second. Marbury Staley Butts is at the Center for Popular Democracy. She is a Soros Justice Fellow there and has been there since the fall of 2013. Her Soros Justice Project focuses on organizing and working with families affected by aggressive policing and criminal justice policies in New York City in order to develop meaningful bottom-up policy reforms. Marbury also works extensively on police and criminal justice reform across the country. And since the death of Eric Garner in Staten Island and Mike Brown in Ferguson, Missouri, Marbury has been involved in national organizing around police misconduct and municipal court reform and has worked with the Ferguson Action Network. Next to Marbury is Ross Garber. Ross is a member of Shipman and Goodwin in Hartford, Connecticut, and the firm's Business Litigation Practice Group. He co-chairs its Government Investigations and White Collar Crime Group and oversees the firm's international trade practice. In addition to litigating significant business disputes, Ross conducts internal investigations and represents clients in investigations and prosecutions by federal and state law enforcement agencies and regulators. His clients have included multinational corporations, federal and state public officials, and agencies, executives, and professionals. He's also represented two governors in impeachment proceedings, Governor Mark Sanford of South Carolina and Governor John Rowland of Connecticut. He also represents individuals in white-collar criminal investigations and prosecutions, and in most of his cases, his clients avoid prosecution altogether. He is the co-chair of the White Collar Crime Committee of NACDL. To my immediate right is Gerald Stallworth. Gerald worked as an Alameda County Deputy District Attorney for 15 years between 1992 and 2007, and during this time as a prosecutor, he tried over 60 cases, 40 of which were felonies, including 25 murder cases and 1 death penalty case. He litigated extensively as a district attorney. He has lectured around the world in Brazil, Malaysia, India, and other countries. He's currently in private practice focusing on criminal defense. In 2008, he joined Death Penalty Focus as their law enforcement outreach coordinator, and he's received a number of awards in the community for his community service. And last but not least is Tanya Clay House. Tanya is the director of the Public Policy Department at the Lawyers Committee for Civil Rights Under Law. She works closely with all committee projects focusing on core issues such as education, voting rights, employment discrimination, affirmative action, criminal justice, and racial diversity issues. As director of the Public Policy Department, Tanya serves as the principal representative for the Lawyers Committee on Capitol Hill and coordinates the committee's policy with state and local legislative bodies. She also manages the Lawyers Committee's communications with the White House as well as with federal and state agencies. She's a former public policy director at People for the American Way, and she began her political career on the Hill as legislative counsel for United States Representative Sheila Jackson Lee, and also worked for Senator Barbara Boxer. So as you can see, we have a great panel, and with that, let's dive right in. I want to start with Gerald, because Gerald, you have the unique distinction on this panel of having been both a prosecutor and now acting as a criminal defense attorney. So I think you have a pretty unique perspective, sort of viewing the grand jury from both sides. And so I want to start with getting your perspective on the grand jury. The criticisms I mentioned before about it being, a tool of the prosecutor, about it being closed and people seeing it as unfair. Do you think that those criticisms of the grand jury are fair criticisms? And what would you see as the pros and cons of the grand jury?
I believe the criticisms are fair. The grand jury does not do what we believed it would do. It does not protect the rights of the citizens from a potentially biased prosecutor. It merely, unfortunately, serves as a vehicle for a prosecutor to reach their desired conclusions. Any system that does not allow a defendant to be present during the process does not protect the rights of a citizen. Any system that does not provide that person, that target, that defendant, to have counsel present doesn't protect the rights of citizens. Any system that does not allow an attorney to confront the accuser's witnesses, to be able to cross-examine those witnesses, to be able to make sure that there are objections to evidence that might be inadmissible, does not protect the rights of citizens. Any system that allows a prosecutor to be able to decide whether or not they are playing by their rules or by the court rules, a prosecutor to conduct a proceeding that doesn't have a referee that can tell you whether or not there's a foul or whether or not it's out of bounds, does not protect the rights of the citizens. Any system that does not provide an environment that's transparent, that allows the public to be able to understand and view the mechanisms that take place, whether or not the proper jury instructions are provided, whether or not exculpatory evidence is provided, does not protect the rights of citizens. I understand that there are a number of reforms that are available, there are a number of amendments that can take place, but I believe at the heart of a system that begins with the right of counsel, that begins with confrontation, that begins with making sure that there's a check and a balance in any system, particularly involving someone being charged or indicted with a very serious crime, requires these mechanisms to be in place. And therefore, with the exception of a few circumstances, I believe that the grand jury system does not work and cannot be rehabilitated.
And so what would you propose instead of the grand jury, if anything?
Preliminary hearings. I believe our system is based on having prosecutors who have enough experience and training to be able to review a report, make a decision whether or not that case that body of evidence is going to provide enough evidence for a jury at some point in the future to decide beyond a reasonable doubt that this person could be held responsible. Once that decision is made, then all of the checks and balances come into place. There's a defense attorney that's appointed or hired that will also review those reports. We'll also have an investigator who will simultaneously work on the case with the prosecutor and the judge for a possible resolution. If a resolution is not accomplished, then there's a preliminary hearing in front of a judge where witnesses are called. Witnesses are challenged. They're cross-examined. Evidence is challenged. There's motions to suppress. It provides an environment not only for the criminal justice system to do what is right, but it also provides the families of both the victims and the defendants and the community to be participants, to be available, to be there, to witness it. I think it provides for more integrity and more credibility to a criminal justice system that has come under scrutiny, most recently given the most recent indictments. So I believe that the preliminary hearing provides the best alternative to the grand jury system.
So you raise a lot of interesting issues that I definitely want to get back to as we begin to discuss it, issues about transparency, issues about the right to confront witnesses against the Sixth Amendment right to confront witnesses, the right to counsel. And I want to get back to some of those, but I also want to turn to you because you're in a state where the grand jury system, I think, works a little bit differently from the way it does in many states. So tell us a little bit about that process and whether you think it's a better grand jury system than others.
Sure, and thanks for having me here, and thank you to NECDL. So there's probably going to be very few people on this panel, maybe nobody on this panel, probably nobody on the previous panel, who defend the grand jury system as it exists now, at least on the federal level. And as we saw from the developments in Ferguson and Staten Island, I bet, and I haven't seen recent polling, but I bet if one were to conduct a poll, there'd probably not be much confidence in the grand jury system among the public. So there's clearly a problem. We should keep in mind that the grand jury system has two main purposes. One is indicting or not indicting. The other is an investigatory body. I think Daryl's comments are interesting, and I think it tees up the question of what might replace a grand jury system. I'm not in favor of getting rid of it entirely. As you mentioned, I'm in a sort of an interesting jurisdiction. On the federal level, we have the traditional federal grand jury with all of its problems. In the state system, we have essentially no grand jury, which creates other problems. On the state level, almost all prosecutions are made unilaterally by the prosecutor without any check. There is a right to a preliminary hearing after the charging decision's made, but for in many of those situations, my clients' lives are vastly disrupted, if not over, before, at least as they knew it, before the charging decision's made. So a post hoc preliminary hearing doesn't do them very much good, especially given that most of those hearings aren't very robust. But in our state, it's somewhat unique because pre-charge, the prosecutor has no authority to subpoena witnesses or documents, which ties the prosecutor's hands. In very rare occasions, a grand jury can be convened, and I'll tell you what those are. The convening of a grand jury is limited to, and I'm going to read from the list because it is so rare that we hardly ever see it. State and local government corruption, Medicaid fraud, racketeering activity, election law violations, and certain felonies, but only where a prosecutor can show that there is no other means of obtaining the information as to whether a crime has been committed or the identity of the person or people who may have committed it. So absent that, those narrow band of cases and that very high showing, prosecutors have no authority to subpoena witnesses or documents, which in many cases is a defense lawyer's dream, but you can imagine how difficult it becomes to do any serious investigation of lots of crimes. The other unique thing in my jurisdiction is that the grand jury isn't really a jury. The grand jury is actually a judge or a panel of 3 judges. So the way it works is the prosecutor makes an application, makes these showings, and if the judiciary agrees, it appoints either a judge or a panel of judges which take testimony. And some of the protections that have been discussed and proposed by NACDL and on the last panel attach in these proceedings to the point where actually some prominent criminal defense lawyers in the state have proposed expanding the grand jury. And to give you an example of how it works, again, it's very rare. I've had a client testify, a prominent client testify in a public corruption investigation, and the way it worked was the testimony was held in secret. In fact, at a state police safe house, so that no one knew people were coming and going. The prosecutor, the judge, the witness, and me as his lawyer sat around a table, and the prosecutor and the judge were able to ask questions. I was able to advise my client. And at the end of that process, the grand juror, namely the judge, doesn't have the authority to indict or not. That still is retained by the prosecutor. But the judge must issue a report which may, if it's in the interest of the public, be disclosed. And many people involved in that process think that actually is one that goes a long way to engendering public confidence and also protecting the rights of witnesses and the accused. And I know we're going to talk more about some of those issues, but it is a unique setup.
So that is interesting, because that is quite different, I think, from the way most grand juries work. And this actually is kind of a good segue into the question I wanted to ask you, Tanya, because you, in your position at the Lawyers Committee, you work frequently on legislative proposals and you communicate with people on the Hill. And so I wanted to ask you about a bill that Congressman Hank Johnson introduced called the Grand Jury Reform Act, because in a sense, some of what Ross talked about how the state grand jury system works sounds a little bit like part of what Congressman Johnson is proposing.
You're exactly right, and in fact, as I was listening to Ross's statement, I was thinking to myself, oh, well, maybe that's where Representative Johnson got the ideas. But you know, you're right. It does. There are some similarities, and I think what it is that it's the goal. The ultimate goal is to provide the necessary transparency, and I think that's what we just heard, which is one of the the benefits, and I think why many in the community probably support or like the current process that's in that we just heard described. But yeah, Representative Johnson's bill, the Grand Jury Reform Act, it's H.R. 429. It's a bill that he introduced, obviously coming out of what has happened in Ferguson and in New York and the respective grand juries. And the ultimate goal is to provide a separation of power, as well as the necessary transparency to provide some sense of credibility and integrity to the community, in a sense of fairness and justice, I think, that people are looking for, that they don't feel that they are receiving right now from the current process, the current federal process. And so this bill is an attempt, what it does is it utilizes the authority that the federal government has, which is the purse. So it states essentially any, that when receiving certain, federal grant funding, has to abide by a certain process. And so essentially, if there is a police shooting, killing that has occurred, then it immediately kicks into place where within 24 hours there has to be notice given to the governor, notice given to the prosecutor that this has occurred. Again, something that I think many people feel has not been done in a timely manner in the recent incidents that we've been hearing about. So that has to happen. And then afterwards you have to, the purpose is to force a hearing. And a hearing on probable cause to determine whether or not an indictment will be brought. So it forces the type of investigation. And so in doing so, it also creates this separation, as I indicated, to provide the sense of integrity in the system. So essentially states that the local prosecutor cannot be in charge of the investigation. Mm-hmm. Right? It puts the state enforcement agency actually in control during the investigation process. And in fact, within, I think, 3 days after the notice is given, that there has to be a determination of a prosecutor that will actually bring this hearing to the necessary judge who's going to be overseeing this. So that, so we have that separation, and it's a random process accordingly. They'll just, I guess the governor, puts in a random process and by which a prosecutor is chosen. So once again, so that there's no sense of bias that is shown with regard to whether or not an indictment will be brought. And so it does require a hearing to be held on for probable cause, but one thing it does not do, it does not force, it still provides some prosecutorial discretion with regard to whether or not an actual indictment is going to be brought. This is an attempt to force the hearing and the investigative phase of this and make sure that there's some transparency. And then it goes back and says, all right, now you've had all this information conveyed. Now, in light of all of this, you make the decision. Now, the understanding is that the right decision would be made, right? And obviously, because there is that transparency that's provided, because during that hearing, there is a requirement that unless there are certain restrictions conveyed by the judge, that it has to be open to the public. Mm-hmm. So all of this, again, the whole purpose is to provide the necessary independence, a separation of authority, and oversight, as well as transparency. And I think that's what people are looking for. And I know that Congressman Johnson has introduced this, as well as other bills that are attempting to provide a sense of accountability. And I think that there's already been briefings and people have been talking about this. And I think this is a line of thought that you're going to see not only on the federal level, but you're also seeing some of these types of concepts being introduced on the state level.
So it's interesting because, first of all, it applies only in cases involving police shootings. Am I right about that?
Yeah, it specifically says that an officer who uses deadly force against a person and thereby causes the death of that person.
Right, so it applies in those cases, not in all cases.
No, not in all cases.
And what's interesting about it is it does focus on this issue that Daryl's concerned about, which is the transparency. It's almost like it's putting sort of a type of preliminary hearing in there that it's public.
Right.
However, it does then say, okay, now prosecutor, you make the decision. I guess it's sort of, Justice Brandeis, sunshine is the best disinfectant. If everybody sees, then the prosecutor presumably, theoretically, is going to do the right thing because everything is in public. So that's sort of interesting. So you brought us to talking from generally about grand juries to specifically talking about the issue that is a big part of this discussion, which is investigations of police officers who kill unarmed people of color. And so around that issue, Marbury, I want to turn to you because I know that your work largely focuses on that. And so I want to ask you about your views on the grand jury with regard to this specific issue and whether you believe that it is possible to achieve justice in those kinds of cases with the grand juror or if there are perhaps other ways.
So I think that the recent failures of the grand jury, and not only in New York and in Ferguson, but also in Ohio and Los Angeles, where we saw a rash of police killings with absolutely no indictments coming out of that, are kind of manifestations of two major problems in criminal justice more generally that communities are really responding to. And the first one is, we've touched on this kind of unbridled prosecutorial discretion, that the prosecutors have become the trier of facts, they become kind of the judge and jury via this kind of plea bargaining regime, which results in kind of whatever charges are brought become the charges that people face, and there isn't really kind of an adversarial process. But also, I think the kind of complete lack of democratic oversight on state power. And so the grand juries in the original formation were seen and understood as a way to check state power, especially state violence. And whether that's prosecutorial violence, when you put someone in a cage at the end of that, or whether it's police violence, that they were meant to and established from the British system as a way to check that power. And like so many systems that I think were intended to check state power, they've been co-opted in some fundamental ways. And so I think what we see coming out of Los Angeles with Ezell Ford, out of Ohio with John Crawford, out of New York with Eric Garner, and out of Missouri, is this reality that in fact these cases are whatever prosecutors want them to be. And so if in fact prosecutors are friendly with police, which they need to be because of their job, if in fact they're bought by police unions and other corporate powers that have an investment in incarceration of some people and freedom of others, they will reflect that in their decisions. And I think that the community outcry around grand juries, and we've seen bills introduced in California, New York is also contemplating a bill, is a result of this feeling that really communities have absolutely no say and no control and no oversight of this incredibly large and violent system, which is incarcerating, 1/3 of black men, is incarcerating women at incredibly high rates. And it's really changing the demographics and the dynamics of the communities without any kind of actual oversight. And this, in many ways, I think mirrors the police kind of systems, which also have no actual oversight, which are militaristic, where there are CCRBs that have no power and no teeth, that we see all of these very violent state systems that have absolutely kind of no oversight. But I think the solution to that is not to tweak grand juries. I mean, New York, for instance, has some of these protections around defense counsel being present, although not nearly enough. But I mean, we see even in New York that doesn't tweaking the system is not actually solving the problem. What the actual issue is around grand juries, at least I think from the community point of view, is a complete lack of transparency and also a lack of input or oversight. And so what I think is key when kind of discussing grand jury reform is to think about kind of the intent of grand juries and how we can open up the process for the communities, and not for kind of judicial review or for other types of review, but for kind of actual community oversight and input. And to me, I think that means two major things. Number one is the makeup of grand juries, that we see very often kind of grand juries are drawn not from those who are most impacted by state violence, but instead from kind of larger communities. And so Staten Island's an example of that, where we have folks, and I think so is Ferguson, where kind of the folks who understand what it is to be harassed by police or what it is to have lots of your family incarcerated, who have that experience of state violence, are not the ones who serve on grand juries. And so I think part of that is about kind of from what pool we pick grand juries and what constitutes a community because of the world we live in, the kind of a freeway. I mean, for instance, in Ferguson, it's literally one main street that kind of separates the haves from the have-nots. And there's a real difference of experience around state violence and kind of the experience of police and incarceration that happens just on that one street. And so it's essential, I think, kind of have grand juries that are made up of both of those streets. So the joy of your peers is not someone who goes to a different school and has a totally different life experience than you. It's actually of your peers. And then the other part of that is eligibility, that you have folks, when you're incarcerating more black men than who were enslaved in 1850, that you have to include those people in a grand jury pool in a meaningful way, that you don't have any kind of check on state power that reflects your own experiences if you don't have a diverse jury pool. The other part of that for me, and this I think is to the question of kind of what are other checks on power, is about the fact that the whole legitimacy of this system, of the increasing militarization of police officers, of large prisons, of private prisons, the whole legitimacy lays on the idea that we live in a democracy where folks decide who they incarcerate and when they incarcerate them. And the reality is that these communities, not just people who are put inside of cages or incarcerated, but also their families, are disenfranchised from that very system. And so I think it's essential that as we talk about kind of reforms around grand juries, we're also talking about kind of what are ways that we can re-enfranchise folks who are disenfranchised from every single step of the system, whether they're like actually disenfranchised from voting or just disenfranchised via political isolation, that there's a real need to kind of engage with those questions of how do we actually have a jury that represents communities and folks who are going through this process and are able to be involved in setting the priorities, both of criminal justice but also of policing. And so I think not only do grand juries kind of need to be remade in that image of oversight and democratization, but so do police departments. And when we discuss police budgets or police oversight or police discipline, there has to be the infusion of the voices of those who are being policed on a daily basis and whose bodies and psychologies are suffering that pressure and who are making decisions about kind of what makes them safe. And incidentally, it's the same folks who also suffer the most violence at the hands of the community. And so they are also impacted by both sides of those systems. And so I think the question for me around grand jury reform is how do we ensure not judicial oversight, not opening books to folks who may not want to read those transcripts, but how do we really open the process to the communities that are most inflicted on both sides of kind of that paradigm?
And I want to talk about some ideas about how that can be done as we get further into the discussion. But you raise a number of interesting issues, one of which is that what happened in Ferguson and Staten Island is sort of like the script was flipped, sort of, because ordinarily the criticism of the grand jury is that, grand jury will indict a ham sandwich, it indicts everybody because the standard is probable cause, the only person there is a prosecutor, and he or she always wants an indictment, so that's what happens. But what you said is, what happens in the grand jury is what the prosecutor wants to happen, which sort of raises the issue of what happened in Ferguson and what happened in Staten Island, or more precisely, what didn't happen there, which was that the outcry now is not, somebody's so easily indicted, but why wasn't this person indicted? And it appears that sort of like different people being treated differently around issues of race, and also it raises an issue of prosecutors and whether they should be the ones prosecuting police officers, which is what I think the congressman was trying to get to. But I want to sort of go now into a number of issues that a number of you raised, the issue of transparency, the issue of the lack of diversity in grand juries, and some other issues. Let's start with the issue of transparency. So let's go back to why it is that we have secret grand juries in the first place. So and I'll just throw this question out to anyone who wants to respond to it. In theory, what's supposed to be the purpose of having this secret grand jury? What are the goals there, and what theoretically is supposed to, the good of having a lack of transparency?
Yeah, I mean, I can start as a criminal defense lawyer. I think the lack of transparency, the secrecy, is actually important. Okay. I've got lots and lots of clients who've been targets of grand juries, who've never been indicted, and their neighbors don't know they've been targets of grand juries. The newspapers don't know, their friends don't know, their bosses don't know, and so I've found that it's important to have that preliminary phase where somebody is simply being investigated for a crime to be private. Now, having said that, maybe there are exceptions to that. Maybe there should be exceptions to that. Maybe in cases involving significant public interest. And again, this is a reflection on our state system where there can be these exceptions. Maybe in those situations there should be an exception, and a decision should be made to publicize some or all of the results of the investigation. And I've seen it happen where names aren't disclosed, but the results of the investigation are published. But it might be important in certain high-profile investigations where the full results are published. Look, in Ferguson and Staten Island, I think we all know who we're talking about there. And I'm not saying for sure that's a situation that warranted public disclosure, but I think there would be strong arguments where the factors weighing for secrecy might be outweighed by the public's right to know and the public's interest in having confidence in the grand jury system. And I know we're going to talk about other issues, the prosecutor's conflict of interest, but there I think there can be some reforms with respect to secrecy.
So, and I want to get to others who may want to speak on that, but it's interesting because your practice, of course, is a white-collar practice where a lot of your clients aren't maybe arrested publicly ahead of time, because you're saying
oh no,
a lot of times
my clients get treated for the most part the same way, and I've done some regular blue collar cases too. But at least in my jurisdiction, my clients get arrested. And,
So because you were saying that their like their neighbors and other people may not even know that they're being investigated.
yeah.
Right. So I guess what I'm saying is there are a lot of people, however, that go into whose cases are investigated, where everybody knows that because they've been arrested publicly, they've been brought into a public courtroom, and they're on the street. It's a lot more open. I'm just making the contrast.
No, for
right?
sure.
I would add that in this particular discussion, when we're talking about homicide, when prosecutors make a decision to charge someone with homicide, typically in the inner city, it's young black men. And they do so based on not a whole lot of evidence, but the belief that there's going to be somebody that's going to identify this person, somebody that's going to be able to pull together circumstantial evidence enough that they believe at some point a jury is going to convict them beyond a reasonable doubt. And I don't know if there's very many occasions where they're sending those cases to grand jury for review. They're not. When a police officer is involved in a shooting and a prosecutor has to make a decision on whether or not that police officer should be arrested and charged, unfortunately, I feel that some prosecutors are using the grand jury system as an opportunity to punt and make someone else make that decision. And they're giving a grand jury a case that is particularly difficult and challenging. There's no other area of law that's more challenging and hard to master than homicide and self-defense, particularly with a police officer. So to give that case to a grand jury with all of the benefits of a prosecutor not being checked, not being confronted, no counsel, no confrontation, no cross-examination, a jury panel that consists of people who are voters and don't have felonies, a jury panel that consists of people who have driver's license, who don't look like the people that are being victimized by some of the cases involving police brutality, I believe is where we are not engaged in a system that's supposed to protect citizens. And I'll just cite one quick general example. In Alameda County, where we had, in fact, an officer shooting that was pretty newsworthy, it was Oscar Grant that was shot in the back on a BART station. And the prosecutor at the time could have punted it and gave it to the grand jury, but to his credit, charged the person. And that person went through a preliminary hearing, which was public. And that person had his case transferred to Los Angeles for a better venue with a jury pool that would have been similar to Oakland. And that jury came back with a conclusion that it was involuntary manslaughter, a conclusion that Oscar Grant and his family and the community wasn't necessarily happy with. They did not have a lot of criticism because it was transparent from the beginning to the end. Every mechanism that was made available was made available. And there have been similar cases across the country where prosecutors have decided that if they believe that a crime has been committed, they're going to let it go through a course that's transparent, that has confrontation in it, that allows a person to have, whether it's a police officer or a young black male, the right to counsel. And that's where I think we're having the problems with the grand jury, and it trickles down to some of the other cases that involve more complex areas of law. I said earlier, the exceptions of grand jury indictments in the system, I believe, may exist where there's a complex volume of documents, the white-collar cases, the paper cases, those may be some exceptions. But when you're dealing with the delicate, intimate issues in the inner city, I don't see where a grand jury and its system, even with some of the reforms, can ever provide a sense of protection to its citizens.
Can I?
Sure.
Sorry. I just wanted to jump in on that point because I think that the reason that many feel that there is no reform of the grand jury system is because of the underlying problem in this country, which is our criminal justice system, and the way that we do have an over-incarceration of people of color, particularly African American men and women. And with that, that creates a system, an underlying bias that we have. And I think that perpetuates itself throughout the entire justice system. And the grand jury system is part of that process, which essentially perpetuates the bias that many feel exists, all the way from the judge down to the prosecutor, the clerk. I mean, everywhere, every part of that system. And so if you have the underlying bias of the prosecutor, which I think many felt existed in Ferguson, many particularly, as we just heard and we're just talking about, I think it was I think many of us who were outside looking and aware of how the process should work pretty much saw what was about to happen when the McConaughey decided to take this to a grand jury. We said, wait a minute, that we know what that means. It's secret. There's not going to be transparency that's provided that we've talked about, and there's usually a reason, because that provides the necessary cover in order to ultimately not bring the indictment when it comes down, and it does provide that form. And there is no back and forth. There is no process by which the defendant is provided, due process. And there's no cross-examination of any of the witnesses. And so, but for the fact that there was a conveyance of, that the transcripts were provided, many of us would not have known what happened. And I'm not saying that that's somehow justifies what happened in this process. If anything, I think, actually thought that, I don't know, I'm not going to read into intent here, but all I'm going to say is that, seeing reading those transcripts, seeing what happened, it really begs the question as to why anyone could actually reasonably believe that this was a fair process that just occurred here. So I think, as I said, the underlying bias, I think, and if you've got not only the bias of the prosecutor that, is pervasive, not just against African American men, but it could be against an entire community. It could be a bias for the police. So you've got biases on both ends. You've got the judge who potentially is biased on different levels. You also have the bias of the police, because we haven't even talked about how is it that, the law that enables a police officer to use deadly force because of a threat of harm. And, if that perceived threat is based upon the bias, the underlying bias that police officer has against African American men, or a male or a young man unarmed walking down the street in the middle of a community, let's just remind everybody, the middle of an apartment complex. There is no sidewalk. He couldn't go to a sidewalk if he wanted to, but walking down the middle, down the street, if there's an underlying bias there, then there's nothing that would prohibit that officer from using deadly force, because there's an automatic perceived sense of threat. So I think we've got to deal with those underlying factors that pervade the entire system, including the grand jury system, which I think is why there is this perception that we can't fix it, but I'm not saying that I don't know that I'm there, but I do think in the interim, we've got to do something.
So you raised just a number of really interesting issues here, and including the fact that, the prosecutor in the Ferguson case actually took the extraordinary step of releasing the entire transcript. And if you look at the transcript, you will see that he, or at least the prosecutor who was asking the question, pretty much acted as the officer's lawyer, which is totally different from the role that prosecutors usually do. Presented a very favorable picture through the direct questions, and sort of impeached, if you will, the witnesses that would have been the government witnesses by doing things like bringing out their prior convictions, which is something I don't think, Daryl, correct me if I'm wrong, that you'd ordinarily do in a grand jury when you're putting witnesses on. But did everything he could in his power to make sure that there was not an indictment. If you read the transcript, it sort of demonstrates that. You get to a number of other issues that are important, and if we have time, we should get to, which is what the law is with regard to the use of deadly force for police officers, which is very different from what the law is for ordinary citizens using daily voice. It really allows them to use it in a lot broader circumstances. But I do want to get to this issue of the diversity of the grand jury, which is the issue that both Marbury and Darrell raised. This issue of grand juries, if you will, not really reflecting racially the communities that they're supposed to be representing. And I want to talk about why that is and what, if anything, can be done about it. So, Darrell, can you talk a little bit about why it is you think that grand juries oftentimes are not particularly diverse and don't reflect the diversity of the communities?
It begins with how grand jurors and juries are impaneled. They come from a group that is either registered to vote or has a California driver's license or a state driver's license and doesn't have a felony conviction. That by itself takes out a number of people of color. 25% of young African American men who are eligible to sit on a jury aren't because they have felony convictions. Unfortunately, there is a very small amount of African Americans who are registered to vote, particularly in California, so that eliminates another 25% from the pool. As well as being required to have to sit for any long period of time, sometimes 2 or 3 weeks. If you're in a murder trial, sometimes 2 or 3 months. Most people of color don't have jobs that are going to pay for them to sit on a grand jury. So you're knocking out another 25%. We're only getting about 25 out of every 100 people of color to even sit on a jury, not to mention a grand jury. So we're eliminating a fundamental right for the community and for the society to have a jury that reflects the people that are part of it. Last but not least, for the grand jury, another point that is yet to be really discussed is that if you are going through a preliminary hearing and then eventually a trial, there's a process called voir dire, where you get to have an opportunity to question jurors who may not be of color, but you can question whether or not they've had some experiences that allow them to be fair and impartial. You don't get that in a grand jury. You get grand jurors who are typically pro-law enforcement, which is understandable. Not very many people are going to come and sign up for a grand jury if they're going to be looking to be cynical and skeptical. Most of them are going to start off with a belief that they're going to do the right thing, and when you put them in an environment where a prosecutor, who I would point out being a former prosecutor, isn't necessarily maliciously trying to bias or prejudice a grand jury. He or she is oftentimes trying to do the best they can to be objective and fair. I think members from the last panel mentioned that. However, given an environment where you're not checked and when you're not allowed to even, in retrospect, look at whether or not you're doing the job as neutrally as possible, I think it's just impossible to have even the most honest and fair prosecutor in that environment be able to present a case that's extremely neutral. It just doesn't exist, and then you give them a jury that doesn't look like the people that are part of the community, that hasn't been fettered through a voir dire process, and we are creating a system that does not provide the protections that we thought it would.
So I want to turn to you now, Margaret, because you also raised the issue of diversity. I mean, you know, what Darrell says paints a very bleak picture in terms of, like, what do we do about that? What, if anything, can be done to make grand juries more diverse, if that in fact is what you think might help to make the process more fair?
Yeah, I mean, I think that there's a few things. One is around eligibility, that we have to kind of change what it is we think qualifies you for a grand jury, that like this kind of idea that you can't have a felony or have like actual experience with criminal justice, that kind of somehow bars you from the process is not only, I think, incorrect but also offensive around kind of who it is who's qualified to make decisions and what disqualifies you. I think also, I mean, we've talked in New York kind of about the idea of like kind of voting hours being extended, and so maybe the idea that you have like different hours of courts where kind of folks who do have jobs who can't leave their kids have options kind of go at different times. So I think that kind of when we think about reassessing what the point of grand juries are and who should be on them, there's a lot of kind of smart folks who should be engaged in the process of like what would make that more accessible where they're at, that's also a local issue about kind of what the makeup of your community is. But I think eligibility is a huge, huge part, and where we get those names from, that we already know that folks are disenfranchised from voting both de jure and de facto, and how do we kind of engage communities in a different way. And so I think folks talk about kind of neighborhood grand juries, the idea of like kind of drawing from neighborhoods and having kind of community meetings be a way of talking about grand juries, I think is an interesting idea. But I think the idea of really kind of, once we decide what our intent is and who we think, like what we think kind of the point of grand jury should be, if this is about kind of democratic oversight, then we are more interested in having democratic folks and folks who are part of the community be part of that process, and then we change kind of the rules of that and provide child support and provide kind of money for folks who can't take the time off.
So, and also, I'm sorry.
Oh, I was going to actually talk about transparency, so I'm going to let you go, and then I'll come back to it.
No, go ahead. What did you want to say about transparency?
I think that very often when we talk about transparency, and I think this is the same with kind of procedure, that we equate that with justice in some ways. It is as if kind of knowing what the process is or knowing what happened makes us feel as if that's okay or just. And I think to your point, Tanya, about kind of McCulloch and how much he shared, that ideally it's true, as Brandeis said, that kind of sunshine is a disinfectant. But the reality is, if you're in a community that's constantly disenfranchised and constantly discriminated against and constantly the butt of police and state violence, that knowing knowledge is not power. Like in that situation, knowing how those systems work does not make you more powerful, and it's not the same as having actual input in the process or actual say in what happens to your bodies and your communities. And so I think it's important that as we talk about this moment, that we don't confuse either procedural justice or transparency with actual justice or progress. So I just wanted to put that out there.
Okay, so the idea of let me just get back to that point of transparency though before we move from there. So is it better? So you're absolutely right. So it's, I'm putting Justice Brandeis in there about sunshine being, and I'm a big fan of transparency in general for government, especially around prosecutorial power. And you're right. Simply the transparency alone obviously is not enough. But if people are aware of what goes on and they see the injustice, I mean, isn't that a necessary prerequisite to some kind of process for change?
If I can, I think that's one of the good things that came out of Ferguson and Staten Island, is that there has been more transparency about the system. And, through all the talking heads on CNN and MSNBC, all of that, I think more and more people realize that the current system stinks. It isn't fair. And so I think at some level, there does have to be more transparency. Then the question is sort of, what does that mean? Marbury makes a very good point. It's not sort of limited. None of these issues are limited to the grand jury. It includes, the police and the judiciary and sort of, regular juries and the sort of whole system. And I think some level of transparency is actually a good thing. And I think, one of the challenges with the grand jury is it has been so secret. So few people know what's happening in there. Daryl's probably the only, guy on this panel who's ever been inside a grand jury. I've never been inside a grand jury. I've read transcripts. It's not the same. And I think that piece, that lack of understanding, probably does hinder reform.
So even if we have the transparency, though, I mean, let's face the fact. I mean, who wants to serve on any jury? I mean, people are constantly trying to figure out ways to get out of jury service, even regular jury service, much less grand jury service, where they oftentimes have to sit for 2 or 3 months. And so, isn't there sort of a certain amount of public education in communities of color, and particularly in all communities, about the importance of, if you are eligible and can get, and there are these issues of people who work, people who it would be a burden to, but I'm aware of someone whose name I won't mention because this is a webinar, who absolutely is a person of color, progressive person who absolutely could have served on a grand jury and had the kind of job where he or she could have gone, and he or she fought vigorously to get out of grand jury service. And this is someone who's deeply cares about the issues we were talking about. So I mean, isn't part of it too sort of saying to people, when you can serve, you should serve so that your voice can be heard?
And I think to your point about transparency, I think my point is not that either procedural justice or transparency are things that we don't want. They just can't be the goal. Like, we can't be seeking that as the ultimate goal or that be the policy agenda. And to that point, I think part of what transparency does, and to Brandeis' point and to yours, is like the emperor has no clothes on. And so your friend might be like, you know what, actually, like if this is how this is going, like maybe I should be in that space. And so So I think that I think about things as organizing tools. That like if people don't have power to make what they need possible and to demand those things, then you can change a system and it won't actually benefit people. And so how do we use transparency and how do we get folks educated around kind of the power that they actually do have, and then also try to expand that power.
Which is a loop that continues to eventually work. It takes time. I know years ago in Oakland there was a prosecution of 4 police officers. Preliminary hearing, grand jury, 2 prosecutions. The jury hung the first time and acquitted a number of the officers, and we tried it again, and it's still acquitted and hung, but we had 24 jurors make a decision that these officers' behavior and conduct didn't reach unlawful behavior, but that resulted in police reform. We had a federal judge come in and say that I will now require the Oakland Police Department to do these things. I believe we're going to get that with Ferguson. I don't know if we're going to get it with Staten Island, but at least having done that, we are in the process of making sure that we're holding our prosecutors, our police officers, our politicians accountable for what's going on in our community. And it's a process that doesn't happen overnight, but it begins with these unfortunate events. And I believe as we loop back to why it's important to go through the process of a preliminary hearing and a trial versus a grand jury, it gives us even more resources to draw from, to talk about the disparities and the problems we have with the criminal justice system. Not to the extent that we're just talking about them, but we're actually going to implicate and implement these reforms.
And I think that to the point about the community education processes, I think we need to really stress that more as well. I think I could say pretty confidently that before Ferguson or before Michael Brown's shooting and the failure to indict, before any of that, most probably did not have a familiarity that this grand jury process really existed. You know, I mean, unless you've had direct involvement with the criminal justice system, that is not something that comes to the forefront of, that's not part of your knowledge base that you keep and, that you prioritize. So I think that there is a huge opportunity here that we need to take advantage of. People are interested. People now want to know more. We're having webinars about grand jury process, which we've never have had before. So I think that we need to not only educate those of us, we need to talk about this amongst ourselves, but we need to go out into the streets. We need to go beyond our comfort zone and have those conversations and have the town halls, have the educational forums, connect the dots between everything we're talking about here with regard to why is it that we did not have a diverse jury pool. People need to understand, we need to walk through our civics. I mean, the sad, unfortunate things I'm diverging here, but the problem, a lot of the problems we have, continue to have, is that we don't emphasize democratic participation in our process, these days. I mean, this is not an emphasis. We don't even get civics education in schools for the most part in public education now. That has been removed. And so there is a lack of information, a lack of understanding and appreciation for how all of these tools work hand in hand. And I think that is very important, that we need to re-educate and people about how this all works together. And so the transparency is part of that. Now people know what they don't know. And so now they're asking the questions, okay, how do we fix this? Well, this is, let me walk you backwards first. Let me talk to you about how that we got to this place. Let me make sure that you're registered. Let me make sure that not only you registered, you voted. Because then if you actually voted, then you had some control or say over who was on your city council, who then determined who your city manager was, i.e. in Ferguson. Those are the things, it's a process that you get to. And so I think that, really opened the eyes of many people. It's not placing blame per se, because this is a long-term situation that had been created in Ferguson and other communities. But I think that there are many factors that need to be considered as we try to figure out what the next steps are and how we move forward in progress.
Can I jump in quickly? Sure. As we sort of talk about transparency, one of the effects, might be, and I think in some circumstances already has been, that there's a realization that the grand jury is of limited, or in many cases, no consequence. I mean, it's sort of it's the emperor has no clothes issue. And so one of the things I expect we'll discuss a little bit is, all right, well, who in that dynamic actually does have the influence and the power? And it's the prosecutor. And there's that notion that a prosecutor can indict a ham sandwich, but some prosecutors don't like ham sandwiches. and so in
vegetarian.
Well, that's right. And so I'd be interested in hearing sort of some discussion about what we do about that, recognizing that the prosecutorial power is the key to the grand jury, and no matter who's on that grand jury in certain jurisdictions, you're going to get the same result if that's the result that prosecutor wants. And I think particularly in light of the discussions of Ferguson and Staten Island, that becomes a critical issue. In other words, particularly where law enforcement officers are involved.
So you're reading my mind, because that was actually exactly where I wanted to go. Because in terms of Tanya's issues about democracy and voting, you mentioned them, voting for city council. The vast majority of prosecutors are elected officials, state and local ones anyway, are elected officials. And so there's that issue. Many times they run unopposed, they serve for decades, people don't really pay attention to that particular race, and we know all the challenges of running for office, but that's where democracy comes in again. Who is that prosecutor? Is this someone that the community has chosen, who shares the values they share and is going to represent them? And that also raises issues of, again, transparency, because when prosecutors run for office, they generally don't talk about, well, here are my charging policies and here are my grand jury policies. I mean, you've never heard a prosecutor talk about that. In the rare instances when they actually do have to run for office and talk about it, they generally say, I'm tough on crime, and if there is an opponent, and oftentimes there is, the other person says, I'm tougher, and then people choose like that. So it's not a very effective mechanism of accountability for prosecutors. So especially now that we know how much power that they have in the grand jury and otherwise. But since this webinar is on grand jury, I'm going to be focusing totally sort of on the grand jury, because the grand jury equals prosecutor, for the most part. And getting back to this issue of the prosecution, or investigation, I should say, and potential prosecution of police officers who shoot people, what has been raised a lot is, and it is also in Representative Johnson's, Congressman Johnson's bill, is this notion of a special prosecutor, right? So in cases involving police shootings, what about that idea of bringing in a special prosecutor? And if so, who should that person be? Should it be a former prosecutor? Should it be a prosecutor who's currently sitting but in another jurisdiction and therefore doesn't necessarily have the specific relationship with that police department, as was the case in Ferguson, where this prosecutor knew and in fact supported and worked very closely with that police department? Should it be someone who's not a prosecutor who would come in and perform that role? So I just want to throw that issue out. I mean, to what extent is that a possible solution? And again, specifically, I'm just talking about cases involving police shootings.
I'm not a big fan of the special prosecutor, because in the most accountable environment, no one knows that county, that city, better than that prosecutor should. No one should not understand the nature of that particular crime, homicide, than that prosecutor. I'm all for that prosecutor having a chief of staff, a committee of people that he or she can talk to and refer to. But it's akin to me of having someone come in to make a big decision for Barack Obama. He's the president. He's got to make the decision.
It's interesting you should choose that analogy for
well,
the
it's
prosecutor.
the truth.
President of the United States.
When you are the head of a company, or you're the head of a athletic team, I'm a big sports fan. When it's the fourth quarter and you got to make a decision, you don't go ask for a special coach. You don't go out into the stands and ask for somebody who doesn't understand your team to make that decision. Prosecutors got to be held accountable. They have to understand that on these cases where police officers involved, they have to stand up. And if they want to have a committee with them, they want to have a police officer shooting team, which many of them do have, to consult with, then so be it. But I don't believe that we are protecting citizens' rights, or we're holding our law enforcement and our prosecutors accountable by bringing in someone from the outside to make decisions which may be in conflict with what they're really supposed to be doing. So
let me push you on that a little bit, because this is so interesting. Most of the prosecutors or people who have been prosecutors before, who I've talked to this about, have that same response, is that, you can't bring in somebody else. And I'm still trying to understand why that is the case. So you talk about that prosecutor knowing that community, so why is it important that the prosecutor in the grand jury know that particular community? And it's the grand jury is putting on witnesses, and it's the standard is probable cause. I mean, what's so difficult, especially if it's another prosecutor from another jurisdiction, perhaps, maybe, who actually has done grand juries before, but maybe not in that jurisdiction. I mean, why would that be such a difficult?
It's just unsettling that in a environment that should have a community connection, that someone outside of the community is going to come in and have to make a decision. Now, I understand, because there are prosecutors that aren't very accountable, and I run across them across the country, that I wouldn't want them making that decision. But ideally, that's the person that should be making the decision. So I'm all for a committee, a team, community involvement.
I thought it was the grand jury, not the prosecutor that's making the decision.
Well, the prosecutor is going to be in the grand jury. The prosecutor is punting the issue to the grand jury, which is another fine point, is that the grand jury is making a decision to indict based on probable cause. Typically, when you charge a case, you're doing so because you believe that there's enough evidence that a jury will convict beyond a reasonable doubt. You're actually lowering the standard when you give it to a grand jury than you would as a prosecutor, which is still troubling, because, as said before, a grand jury would indict a ham sandwich if a prosecutor tells them to do so. I think on these more challenging cases with homicide, that it requires a group of people who have tried homicide cases, who are familiar with them, who understand that officer, who has pictures information on that officer and whether or not there's any prior bad behavior. Those are the things that have to be taken into account when you decide to charge a person versus sending it to a grand jury and having them listen to an officer who's not cross-examined, talk about what they believe is reasonable fear. I think that's where we are having a disservice, and that's the biggest problem.
So I see both Marbury and Tanya wanting to jump in. So let me go with Marbury first and then Tanya.
So I think two things come to mind immediately. Number one is I think you're right that it would be ideal if DAs were in fellowship with communities in a way that made them accountable. But we've seen over and over again across the country, in case again, with exceptions, Brooklyn just indicted the killer of Al-Qaeda, Oscar Grant you brought up. But for the most part, what we see over and over again is a total failure. And this gets back to the idea of the disenfranchisement of our communities, right? Like we've talked about this, about the voting, about like who shows up, but who is held accountable. And so the idea that like in theory, it would be great, I think, if prosecutors felt accountable to who was supposed to elect them and the communities that they're supposed to solve. But in fact, I think we see both in the intimacy between police chiefs and between DAs, and quite frankly, in the politicization of DAs. They've been elected by, if they do not run unopposed, and there were some money forces that got them there. Often those money forces are police unions, they're often corporate entities that are invested in incarceration. Like, this is not like a pure field. And so I think the bias of local prosecutors, both in terms of the intimacy with police, but also in terms of just kind of generally their relationship with communities, means that it's essential that if there is a case where it involves police violence, that there has to be an outside person to come in, especially when we've seen kind of this failure over and over again. And so we would replace the head of the Eagles if they kept messing up. Like if you over and over again are failing, we will bring somebody else in to do your job sometimes. And I think what I've found, at least across the country, is that families' number one demand is special prosecutors, that they feel deeply, deeply disenfranchised from local prosecution and from that system. And I think that it does, to Tanya's point, kind of speak to like this whole system is broken. That the reason why they want an outside power to come in is because they feel like the kind of what's happening in their own community is not sufficient and is not just, and that is a problem that we should address beyond just appointing a special prosecutor. But I think we've seen over and over again that like, folks really are calling, communities are calling for an outside state-appointed prosecutor.
And I think it really does go to the sense of accountability that people feel they need to have over the system that we serve under. And if there is a feeling of lack of integrity within that system, you can't deny that, because if that is there, then indeed you're going to perpetuate the cycle of people being disengaged and the overcriminalization that continues to happen because of the bias that people feel, and it just continues over and over again. And so I think it's, I found it peculiar that I hear the argument about ideally you would want someone who understands the community, but from the standpoint particularly of many, that's the whole reason why you don't want that person actually prosecuting a particular case of a police shooting or killing, because they have that type of familiarity that should have nothing to do with whether or not there is going to be an indictment brought. And from that is the perspective that I think that many, communities and families that are that are affected by this process maintain. And that is why. I mean, the sense of independence and accountability is something that we have dealt with, that we deal with on multiple levels on many issues. It's not just within the criminal justice system. The whole point of the federal government coming in to oversee and maintain authority over the states and certain in certain arenas is precisely because there's a lack of accountability and maintenance of integrity within the system. The whole reason why we have why we have if you want to use the analogy of the president versus the criminal justice prosecutor, that I'm going to use the analogy. Well, you have a public school system, that if you ideally it's supposed to provide equitable education to all students. Then the reality hits. Mm-hmm. That is not how it, how the reality is for children within the public school system. You have the state system that actually, the state-based system, the local taxes, that sets up a system of inequality within our public schools. And so there's the ideal, and yes, I appreciate that, but then there's a reality that we've got to confront, and we have to deal with that, within the states. And I think that we cannot deny, and until we get to a point where, yes, we have the sense of where maybe we are able to say that prosecutor, regardless of the familiarity and association with those that he works with every day, will consistently do what is necessary in order to further the cause of justice within our system, within the grand jury system, whatever. We have to have something that provides that sense of integrity and accountability in the system. Otherwise, we're failing, and people are no longer going to abide by the system that we're within, and then we have anarchy. and that's not what we're looking for.
Which in some ways was what happened in Ferguson.
Yeah,
where you had a
people don't appreciate it,
and who thought he needed to do the job, but then had to twist himself into a pretzel to try to figure out how to do it in sort of kind of a way that would sort of kind of work and sort of kind of be accepted. And I think it reflected the reality that, we're all human beings, and it becomes very hard for a prosecutor in that situation, even one that's well-intended, to be able to do the job with respect to an officer in his or her police department, essentially on his or her team. I mean, it just doesn't work.
Did you finish?
No,
I think. So, I mean, the other issue that was raised, and I don't want to get too far afield from the topic of the grand jury, but a number of you raised it, and it's sort of hard to avoid, is this whole idea of the police officers and the use of deadly force. And Tanya, you raised this issue of implicit bias, which is just one that is such a big issue now in so many areas, particularly the criminal justice system. The fact that the law, through a series of cases, Tennessee versus Garner, Scott versus Harris, and others, where the Supreme Court has basically said, the Supreme Court has given police officers a lot of leeway in using deadly force to effect an arrest. In Tennessee versus Garner, to stop a fleeing felon, the court, said, the police officer has to believe that he is there's a reason to believe that he's in danger of serious bodily injury or death, or others are in danger of that, before using deadly force. In Tennessee versus Garner, the court said that cop didn't, and so that deadly force should not have been used to stop that fleeing felon because those findings weren't there. But then in Scott versus Harris and others cases, the Supreme Court has said that there's this mushy standard of reasonableness in terms of whether police officers can use deadly force. Was it reasonable under the circumstances? And I think what a lot of times people think is just because the Supreme Court has said something's not unconstitutional doesn't mean that they have to do it. So in other words, the Supreme Court didn't say police officers, you should kill people when you're making arrests. It just basically said if it's reasonable under the circumstances, and they look at particular fact patterns and say, well, it was reasonable under those circumstances for you to use deadly force. So that mushy reasonableness standard, just to sum it up, gives police officers a much broader range of circumstances in which to use deadly force than you or our ordinary citizens can do when acting in self-defense. So the question then becomes what to do about that, and how is it, you raised the issue, Tanya, of a police officer who says, I was in fear when I saw this large black man running down the street. I thought that my life was in danger, even though he wasn't armed and all that. And so that gets to these underlying issues of racial bias and why were you necessarily in fear? Do people see black men and automatically think fear, and then does that give me license then to use deadly force? But getting back to this issue of the grand jury and the prosecutors, so prosecutors are not over the police departments, right? The police, they're not, the prosecutors aren't the bosses of the police. And so it comes to an issue of, a change in policing, and but prosecutors don't, or do they have any influence over that change? I mean, or are they sort of just dealing with the hand that's dealt to them? In other words, can they have any influence over how police departments conduct business with regard to the use of deadly force, or is that sort of this not the prosecutor's job? And once it comes to the grand jury, if the cop comes in there and says I was in fear and the grand jury believes them, then are they sort of stuck with that?
Well, prosecutors not at the police academy helping them to train, not producing the manual, and not laying out to them exactly what their reasonable fear of deadly imminent harm will be. However, a prosecutor, by way of charging and prosecuting, can let police officers and department know that there are going to be certain scenarios that they're not going to find to be reasonable and self-defense, and they're going to charge. And that will have that effect. It has that effect in Alameda County now, because we've charged police officers, and they understand and know what those scenarios are. I don't think we're going to be able to change that manual. I believe that although there's a lot of skepticism and there are understandably communities that are not believing in the police department overall, when you ask people to put a gun on their hip and patrol the inner city, they are going to get somewhat of a broader range for their actions. It's just inevitable. However, if we are calling them on those cases which a jury could find them responsible, then we're at least making it less susceptible for some of the behavior across the board, and that's the beginning of that reform.
And I think that to that, I definitely agree that there is, by actions, and I appreciate that, by actions the prosecutor can kind of lead the police force into the right direction. And I think we can also, there's other ways we can talk about the best practices and provide examples of good policing tactics that will provide the necessary, that will help to provide the credibility and maintain the integrity of that police force, so that therefore the community respects, the police officers that are walking through their neighborhood, because they understand that there is no underlying intent or malintent, that they are serving. They're there to serve and protect, and that and if people respect that process, I think that we can maybe get to a better place. And I wanted to provide an example of what there has been, there are, for various reasons, I mean, either through consent decrees or through other technical assistance that's being provided voluntarily or involuntarily by some, to some police forces, we've gotten some examples. So, for example, in Las Vegas, in the police department there, they needed to address the police officers' use of force, especially against the people of color. And so, instead of obviously there's a need, they wanted to deal with maybe some of the biases that were underlying this police officer's use of force. They recognized that we maybe, even as we're trying to get to that, let's deal with the process. So maybe we can just take it where we are and move and deal with the process by which this is happening. And so they recognized that there's most of the incidents occurred after there were pursuits of the suspects on foot. And so the department adopted a new policy on foot chases, in which it said that the pursuing officer would no longer be allowed to touch the person being chased, and that if the use of force was necessary, a partner who was not involved in the pursuit would step in. And so they decoupled the prejudice from the behavior. And as a result, the use of force in foot chases and overall use of force against people of color declined drastically after the policy went into effect. Now, again, it may not get to dealing with the underlying, biases that may continue to exist, but if we can, just like the federal government can't force a change in attitude of those who have been bigoted or racist all their lives, but you can force you to respond and act and make you behave under threat of prosecution. So that's what this did. And I think that is something that we should use as an example, as other ways in which we can deal with some of the problems that are occurring in police force. And I think that many of us don't feel that, okay, all police are bad. That's not what people are saying. In fact, we know that most are out there trying to do their job and protect us and do what is necessary. They have signed up for a service that many of us will not ever choose to do. All right, that is something that we applaud that. I think what we're saying is that you have those bad actors, and maybe those who have their own personal issues that are because they're human, they're bringing those to the job, and we've got to deal with that, and we can't ignore it. And so let's deal with those realities that we're facing and try to put in some better processes that can decouple that type of underlying bias from the actual behavior.
The other side of that, to me, I think, is also in terms of discipline inside of departments, that there has to be early warning tracking systems that identifies folks who have issues around excessive use of force. Because these killings don't just pop out of no place. These officers normally have histories, these specific officers, of complaints of use of force. And so having, I think, CCRBs or civilian oversight boards that have some teeth that actually have an impact on, your career prospects, having early warning systems, having preventative measures that you've just mentioned around, how do we stop the escalation of these incidents. I think there are ways both in terms of de-incentivizing it from the criminal justice perspective, but also before we even get to that place, how do we take civilian interaction seriously? I think another way of talking about it is also we have quota systems in departments across the country that incentivize arrest and negative contact. And what if we change those to civil rights metrics, where we ask, how many fights have you de-escalated today? If there were other ways of measuring your success that weren't about negative physical contact with kind of community members, that would go along with. I think the cultural issues that lead to this moment inside of departments are things that we can address without kind of the hammer of criminal justice sometimes, and that we should. And when it gets too far, we have to adjust it with criminal justice in a way that's fair. But there's a lot to be done before we get there.
So I guess I want to bring us back to the question, and then this will be your opportunity as we conclude our panel. I want to ask each of you, if you will, if you could suggest one reform that would help to achieve racial justice, or racial fairness, I should say, in the grand jury, what would that be and why? And it may be something you've already mentioned, obviously, but just sort of, what's the first step? And then not to say that this is the only thing, because I think all of us can agree that there's sort of no one answer to this very complex problem that has so many layers. But what would be one suggestion you would make that would help to reform the grand jury process? And Margaret, I'm going to start with you and just go down.
You only get one.
Just the one. I'm going to say eligibility and makeup, but I also think that it's a moment where we.
One.
I know, but see, the and with the clause.
And you said it real quick.
I know. I was like, but I think that to me
Explain
is a
again
question.
what you mean by eligibility.